to pardon, my lord, transfer application, your lordship.
No.
Your lordship, the petitioner is suffering from 100% disability. Due to
No.
applicant, your lordship,
No.
My lord, anticipatory bail.
No. No. Anything else? Anything exceptionally urgent? Please make a mention.
No, pardon, one KRB my lord, petitioner.
Only 7 days remain. 7 working days remain. How can you expect the court to take up these matters?
16 तारीख अच्छी तो lady by lord, pregnant lady. Husband file करते.
Yes.
3 to 13th May.
Please appreciate. It is not possible to take up these matters before vacation. Already, previously adjourned matters are being adjusted. 7 days remain. We can take it up after vacation. Comfortably.
Election जो drive election चालू जो केतला ask करे तो
Addendum make a mention, Malaj. The writ petition of the concerned bench of Justice Biraja Prasanna Satpathy, Malaj, is not functioning, Malaj. The matter relates to the EPF Act, Malaj.
So it has not come.
Malaj, there is a notice. There is a notice.
Mentioned before me.
Lordship.
What's he? Exceptionally urgent matter. What is the urgency?
Malaj, the order has been passed on 18th April, and the tribunal has directed me to pay the 25% of rupees 1 crore by 30 days. 30 days will be 18th of May, Malaj. Much obliged, Lordship.
But I think Justice Satpathy's bench will start functioning from tomorrow.
Friday there is a weekly waste.
No, but tomorrow I think it will function. I'll find out.
If not, Malaj.
যদি কালি তাଙ୍କର বেঞ্চ ଥିବ ଆଜି ନବାର ଆମର କିଛି ଆବଶ୍ୟକତା ନାହିଁ କାଲି ଯଦି ଅଛି ତାହେଲେ ଆଜି ନବାର କଣ ଅଛି କାଲି ଅଛି କାଲି ଯଦି ଅଛି କାଲି ଯାଏଁ ଯଦି ରହିପାରୁନ ଯଦି if there is something so urgent
by 18th Malaj
18th we have not reached 18th so
if not tomorrow I will liberty to mention tomorrow if
yes
not too late
settled
But don't mention that. Man, this is RSA matter. Actually, 2008 मसरे से हाथी दड़ी मार दी थी ला compensation type on से against state अतला से
एक सुना नहीं ही परिवन vacation पर make a mention after vacation we'll take it. No after vacation yes
Pardon, I want to say to save your lordship's valuable time. For that reason, I am mentioning item 22. It is calling admission for acceptance of the requisite restive post. Wrongly, I have Sunipan ne de dechi restive post requisite ta speed post order rahitala. So for that reason, matter has come. And it should be listed in orders category. It is in admission.
Mr. Das, let it reach. Let it reach. So file ta kholi ki te apna order ta kar do. Yes.
Not list item number 1 for judgment.
In the result, the writ petition is allowed. The impugned order under Annexure 8 is hereby quashed. The opposite party authorities are directed to reinstate the petitioner in service, granting him a continuity in service from the date of disengagement till his actual reinstatement notionally. In other words, the petitioner shall not be entitled to any financial benefits for the period during which he did not render any work to the government. This order shall be carried out within 2 months from the date of production of certified copy of this order.
Item number 2 for judgment.
Thus, after going through the impugned judgments vis-a-vis the grounds raised in this appeal, this court finds no error in the findings of the court below so as to be persuaded to interfere. For the foregoing reasons, therefore, this court finds no merit in the appeal, which is therefore dismissed, but in the circumstances without any cost.
Item number 3 for judgment.
For the foregoing reasons, therefore, the writ petition is allowed. The impugned order under Annexure 5 is hereby set aside.
Item number 4 for judgment.
In the result, the appeal is allowed. The impugned judgments are set aside. The suit filed by the plaintiffs is decreed by holding them entitled to recovery of possession of the suit lands from the defendant, subject to the condition that they shall refund the consideration amount of rupees 67,500 each received by them to the defendant along with interest at the rate of 7% per annum, calculated from the date of receipt of the amounts by them within 3 months. Further, the counterclaim filed by the defendant is dismissed. There shall be no further order as to costs.
Item number 5, press admission.
Item number 5 kindly pass over your lordship.
All right.
Item number 6.
My senior lawyer.
All right. Excellent. Yes, Mr. Thor.
My lord. Wait, please, Lord. And here is a case. My lord, the petitioner has filed this application, my lord, with a prayer
to transport the case from Baleshwar to Bhadrak. My lord, you will see the FIR.
The petitioner is the accused.
My lord.
Order.
Accused, and he is a practicing lawyer of Bhadrak.
Yes.
My lord, whatever it may be, my lord, the case registered against him for the offence under section 376 and 506 of the Indian Penal Code.
Yes.
My lord, we see the FIR at page 13.
Yes.
It is, the victim is a resident of Bhadrak, my lord.
Yes.
Under Bhadrak PS. Whatever the allegations she is making, that
Theft.
kidnapping, theft,
Juvenile misappropriation.
498, where the victim stage. Well, that has been categorized by the apex court in a number of cases.
All right. What I will do is I will go through the case diary.
My lord.
All right. You take instructions and also try to address the court with regard to the provisions under chapter 13. Section 177, you have to address the court on section 177.
177 is very clear, madam.
Because ordinary place of inquiry and trial.
My lord, but as stated by the victim, my lord, that Amogara Pora, she is staying at father's house.
Hmm.
So the occurrence take place at Simuria piece. Under Simuria.
Nowhere.
ठीक है हम देखिए let us see the case diary इधर खाली जाना पड़ेगा तब statement थी वो ये थी वो सब देखिए all right up to date case diary be obtained further Learned State Counsel further the parties are requested to address the court as regards applicability of the provision under section 177 of CRPC and the related provisions under chapter 13 thereof. Stop. List this matter vacation for an hour.
2nd July.
2nd July, Mr. Mishra?
Aye.
2nd July. What IA?
Stay for the proceeding.
All right. Further proceedings in ST case number 46 of 2023. Pending in the Court of Learned First Additional Sessions Judge Fast Track Court. Fast Track Court?
Balish.
Is there a Fast Track Court there?
Yes, madam.
First Additional Sessions Judge Fast Track Court Baleshwar shall remain straight till the next date. Is there a Fast Track Court? Has it been committed? It must have been committed, otherwise ST number kinti ala. Yes, Mr. Mishra, please address the court on that.
My lord.
You have to find out where the occurrence took place,
My lord,
not
that is
where the victim resides.
My lord, that
She may have given an address, all right, but then what was the investigation in this regard? What has the investigation revealed? All right.
My lord.
So that is why I call for the case diary, even in a transfer application.
My lord,
Yes.
only that is the issue, my lord. In which place?
But if it is found that she has been residing within the jurisdiction of
Sasrogare is Bhadrak town.
no, if she has been residing, what she says that amo ghoru ko asiki. So amo ghor ta kou jaga?
Sasrogare.
That we have to find out.
Because she has categorically stated in annexure 1, my lord, Messi. ମୁଁ ଶ୍ୱଶୁର ଘରେ ମତେ ମୋର ଶ୍ୱଶୁର ଘର ଲୋକମାନେ ବି କେହି ସାହାଯ୍ୟ କଲେନି ସେତେବେଳେ because what was ballot I should not say against a lady she is having some antecedents she is involving with others like that for which her in-laws ballot means he annexed to her in-laws scolded her and dissuaded her not to do it for which a case of 294 323 354, 379 has been registered against the in-laws. Again, she was found caught red-handed with another boy of that locality, for which annexure 3, while she has categorically stated, she tapan mosagar thila boli se mate barabadi kale for which a case of 498 has also been registered.
Well, I think the case diary.
Both the cases have been entered in final report 3 days back.
No, but I think the investigation will reveal where she is residing.
Yes. Everything.
They cannot create obviously a place of residence. All right. Yes. I do not say.
Petitioner pledged to transfer the MAT case number 6 of 24 from the court of the Civil Judge Senior Division Koraput to Family Court Baleshwar, madam.
On what ground?
On that, now the wife, the petitioner is staying at Baleshwar.
All right. Take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow.
Yes.
List this matter.
2nd July.
On 2nd July? On 2nd July 2024, आइए करूँ तो further proceedings in MAT case number 6 of 2024, pending in the Court of Learned Civil Judge Senior Division Koraput, shall remain state till the next date.
Item number 7.
May I please report? My lord, petitioner being the wife of the opposite party, praying for the transfer of the section 9 application filed by the husband before the judge family court Raigada to Barampur, my lord. She is residing with her in-laws, my lord. On the ground that on the very next day they started torturing her and
No, where is she residing?
now residing with her in-laws, my lord.
In which place?
Ma'am?
In which place?
Barampur, my lord.
Barampur, all right. Take notice, issue notice to the opposite party by speed post with ID. Speed post, fixing a short returnable date. The requisites be filed by tomorrow. List this matter on 9th July. Further proceedings in CP case number 35 of 2024. Pending in the Court of Learned Judge, Family Court Raigada, shall remain stayed till the next date.
My certified copy in course of the day matter posted to tomorrow, my lord.
All right. Urgent certified copy be granted in course of the day.
Item number 8.
May I please report? The status to file the counter. They have served the extract of this.
Instructions have been received.
Item. Yes. Receive the to provide the accountant from DO on the basis of guideline. This has come for fresh admission.
Yes.
Yes, ma'am.
The collector shall be subject to result of the writ application. Yes.
No, instructions have been received. We will be filing the counter affidavit within.
Let them file counter.
The interim to continue.
Obviously, it will continue. Where is
Right.
over
Apply to it.
it? Sri Hardas Leonard AGA submits that he has received the Paravise comments. Paravise comment
Yes.
and shall be filing a counter shortly. He requests for an adjournment. List this matter. Vacation for it. 9 July. Counter affidavit, however, counter affidavit be filed within a week after serving copy on the other side. Stop. Rejoinder, if any, be also filed in the meantime.
Item number 9.
Hon'Ble.
Letter relating to my lord, disengagement of the petitioner for the post of the my lord Anganwadi helper.
Anganwadi helper, yes.
My appeal is pending before the opposite party number 3 my lord, annexure 7, page 17.
Opposite party number?
Opposite number 3 my lord, sub collector Chompua. It is
As per the
annexure,
new guidelines.
my lord, yes, my lord. Here, my lord, I was,
As per the new guidelines.
my lord. The guideline, my lord, annexure 8, page 19. There, my lord, I was properly selected,
What is this guideline?
my lord, annexure 8, page 19, my lord. There, my lord, I was properly selected by the opposite party.
Guidelines for selection of Anganwadi worker. It a date kahin, kaun kahin?
My lord,
Where is the date? Who has issued this guideline?
that,
This must be a part of some guidelines.
yes,
Where from? Who has issued this guideline?
There is no mention.
No mention.
so.
So, the appeal lies to the sub-collector.
Sub-collector, my lord.
So, when were you disengaged?
This guy, my lord, annexure 5, page 15.
This is 2024, so the new guidelines will apply.
Yes.
Mr. Das and Mr. Patnaik, please find out the new guidelines. Who is the appellate authority? Please find out new guidelines. Sir. Passing it over.
New guideline is from March 2023.
No, it is 2024 year is, but
Yes.
the new guideline will apply.
Yes.
Yes.
Please find out who is the appellate authority.
Appellate authority, my lord, with
For
respect
Anganwadi
to
helper.
helper.
Yes.
So, correct.
दिखाई दे लो हमारा so you hand it over to Mr. Patnaik.
But-
Thank you. We'll pass it over.
Yes.
Pass over. Just one pass over.
Item number 10.
Oh, 10 is a no. We'll wait. 10 will take time. So it is Sarava. Asun. ये देखिए तुम संग संग.
Send down. After respect, my lord. This is with respect to Anganwadi workers, my lord. Helper ଟା ଯୋଉଟା ରହୁଛି
Helper କିଛି ନାହିଁ.
ତାଙ୍କର ଏଟା ଅଙ୍ଗନୱାଡି ୱାର୍କର ଆଉ ମିନି ଅଙ୍ଗନୱାଡି ୱାର୍କର ପାଇଁ ଏଇ ଯୋଉ ଗାଇଡଲାଇନ
Okay.
ହେଲ୍ପର ରେ ସବ କଲେକ୍ଟର ପାଖକୁ ସେ
How do we know that?
ଇନଫ୍ୟାକ୍ଟ
How do we know that? We'll call it tomorrow. You take instruction. All right. We'll call it tomorrow. List this matter tomorrow. Learned State Council shall inform the court as to who is the appellate authority in respect of appeals filed by Anganwadi workers. Anganwadi helpers. No, who is the appellate authority against appeals filed by Anganwadi helpers? Yes.
Helper.
ସେଇଟା କହୁଛି ମତେ
In respect of disengagement ବୋଧେ ସେ।
in
କାରଣ
respect
ତାଙ୍କର
of- in
ଦି
respect
ପ୍ରକାର
of their
operator।
disengagement.
ଗୋଟେ ସିଲେକ୍ସନ ପାଇଁ ଗୋଟେ ଅଲଗା
Yes.
ମୁଁ ଧରି
Item will come tomorrow. Item not 10. Item 10. Item 10, yes. Where is Mr. Das?
That's it coming now. My lunch will start.
Yes.
I said 10 minutes. I'm
Yes,
looking at the watch.
I'm conscious of that.
No, I thought you might have forgotten, so I wanted to remind you. At least I have not forgotten.
Yes.
Diyo, kagaz diyo. Mo kagaz oda diyo.
Well, so far as, well, your lordship may kindly remember, in order to refresh your lordship's memory,
Yes. Kagaz oda diyo.
yesterday I argued for your lordships that three persons, one petitioner, one Emendas, and one Tapan Kumar Naik, filed OJC number 6101 of 1999.
Where they are admitted their,
Yes, admitted.
that I've seen.
One Emendas, he also got similar order from the director regarding validation of his appointment. Well, your lordship may kindly see that writ petition.
So he challenged it.
No, my lord may kindly see.
No, did he challenge that order?
No.
only?
Governing body challenged that.
Same thing.
Governing body filed a writ petition, that is WPC number 9101 of 2005.
910.
I have not given the entire.
Justice Sujit Narayan Prasad. Yes.
I have given the entire, I have not given the entire annexure. Your lordship may kindly see annexure 4 at page 12. 18/4/2005 order that was passed by the director in his
Annex
favor.
4 in this.
Internal page 12. Say memory. Annexure 4 at page 12.
Yes.
That order was under challenged. This is relating to
Even Das.
Das. My lord may kindly say, relying upon that resolution number 30 and 40, my lord
Yes.
may kindly come to page 40. On verification of original GB resolution book of the college, it was found that the above resolution, that is GB resolution number 30 dated 17/7/93 and number 40 dated 27/3/98 are missing and have been torn down. Then other things are there. Then your lordship may kindly see the last but one paragraph.
Yes.
In view of the above premises, it is clear that the applicant Sri M.N. Das, lecturer in public administration, in the second post admissible to the college, was appointed by the governing body of BNMA College, Palyabindha, and he joined his assignment on 21/12/92. He is in receipt of monthly salary from the management till date as verified from the college records, acquittance rules. Thus, the case of Sri Das is to be validated under Odisha Aided Educational Institution Appointment of Lecturers Validation Act 1998, as he is eligible in all respect, being appointed with requisite qualification. This order was challenged by the governing body by filing this writ petition, that is WPC number 9101 of 2005.
Yes.
I have given the order passed in that case.
You have given a typed copy, perhaps?
Type copy I have given. Your lordship may kindly come to page 18.
Yes. We can go to the findings straight away.
Yes. Your lordship may kindly come to page 19. The third paragraph. This court has perused the copy of the writ petition bearing OJC number 6101 of 99, that writ petition, wherein the opposite
Which
party-
writ petition? The other, which was withdrawn.
Yes, withdrawn. Wherein the opposite party number 3, who was petitioner number 9, wherein relief sought for is to quash the letter dated 22/4/99 relating to the cut-off date, that is 31/12/92 of the Validation Act. On the ground that the opposite party number 3, since been appointed on 3/9/96 and joined his service on 9/9/96, as per the averment of the opposite party number 3 in the said writ petition, that due to fixing of the cut-off date as 31/12/92, he will be deprived of from the benefit of Validation Act 98, having been promulgated by the state government to validate the service of other lecturers working under the different educational institutions of the state. According to the learned counsel for the petitioner, the writ petition bearing OJC number such and such has been withdrawn by the petitioners, as would be evident from the original record of the said writ petition. It is evident from the pleadings made in OJC number such and such, especially in the paragraph 5, which is being reflected here in below, The entire paragraph 5 has been quoted.
We need not go. Yes.
Yes.
Then I think it is submitted that.
It is submitted here that the petitioners were validly appointed by the governing body and the appointments were made by the governing body in adopting proper selection procedure. The appointment orders issued in favor of the petitioners by the governing body are annexed herewith as Annexure 1 series. The opposite party number 3 has subsequently approached before the director for validation of his service on the plea that he having been appointed prior to 31/12/92. The director has issued the notice to the governing body. The governing body has produced all the relevant documents to substantiate that the opposite party number 3 has been appointed on 3/9/96 and joined on 9/9/96, and as such he cannot be held entitled for the benefit of provisions of the Validation Act 98. And the copy of the writ petition being OGC number such and such has also been brought to the notice of the director, but the director has not put its reliance upon those documents and given declaration regarding appointment of the opposite party number 3, treating his appointment prior to 31/12/92, and accordingly directed to validate his service under the provisions of the Validation Act 1998. It is evident from the record that the opposite party number 3 actual date of appointment is 3/9/96, as has been discussed herein above, as would be evident from the pleadings made in OGC number such and such. The other documents has also been perused by this court, which is the application filed by the opposite party number 3 for consideration of his candidature for appointment as lecturer in the subject in question, and that application is dated 27/96, wherein it has been stated by him regarding consideration of his candidature to be considered in the light of the advertisement published in daily local newspaper Sambad on 15/7/96. These documents, though produced by the petitioner before the director, but the director has not considered it. Learned counsel for the petitioner in course of argument has produced the order of approval dated 5/6/2013. I will take your lordships to that order as contained in office letter number such and such, wherein the date of joining of the opposite party number 3 has been reflected as 9/9/96, as would evident from column number 3, where his name and name find figures. The opposite party number 3 has filed a rejoinder affidavit to the counter affidavit, but this factual aspect has not been disputed by him. In that view of the matter, the order dated 18/4/2005 under Annexure 4 passed by the Director Higher Education Orissa Bhubaneswar cannot be held to be sustainable in the eye of law. Accordingly, the same is quashed. So now your lordship may kindly see that order of the where they accepted the position. My lord may kindly see that document. The governing body has given that document. The counter filed by the OP number 3.
We are seeing this writ application.
No, not writ petition. Yes, writ petition. My lord, counter filed by the OP number 3, governing body, in WPC number 12466 of 2009.
That is what I'm looking.
Yes. My lord, may kindly.
Preliminary counter affidavit, yes.
Yes. Annexure F/3.
F/3, yes. Copies of the order passed in respect to the prisoner.
My lord, approval order.
Approval order is very dark.
Serial number 6, Sanita Tripathi, second post. Her date of appointment is 22/12/93.
Yes.
Saroj Kumar Mahapatra, 29/12/94.
Yes.
He accepted that position, and M.N. Das is also there.
Yes.
M.N. Das, serial number 3, 9996.
Yes.
Which case I have cited before your lordships. So this was accepted by them. Then, my lord, so far as my appointment is concerned, the opposite party number 4 appointment, your lordship, for a moment, your lordship may kindly come to Annexure H/3 at page 30. I was initially appointed on ad hoc basis.
Annexure F/3.
H/3.
H/3. Yes.
I was initially appointed on ad hoc basis on 19/12/93.
Yes.
Then, your lordship may kindly come to Annexure J/3 at page 31. A resolution was passed by the governing body on 8/8/97, regularizing my appointment. My lord may kindly come to page 32. Second paragraph. Further, the governing body today decided to regularize the ad hoc period of service of Ms. Anita Tripathi, lecturer in political science from 12/12/93 to 13/3/95. Her date of joining will be treated as 22/12/93 instead of 14/3/95. The principal is requested to pay the arrear salary and regularize her service. Then your lordship may kindly come to Annexure J/3. My salary was paid.
Acquittance roll.
Yes. Thereafter, My lord, another point I am raising, my learned friend has annexed the EPF order. He is relying heavily on that. EPF order at page 75. Page 75 of the writ.
Yes.
My lord,
Yes.
here your lordship may kindly come to page 76. The names of these three lecturers are there. Tapan Kumar Naik, he claims that EPF should be deducted from 21/12/92 instead of 88/96. Now your lordship may kindly come to serial number 3, Sri Saroj Kumar Mahapatra.
Well, for a moment I was taken aback because when I was a lawyer, I was conducting some EPF matters in respect of some lecturers. Exactly similar. Exactly similar. So I was for a moment, I thought it was my.
Yes.
As a lawyer.
Your lordship has got vast experience.
Vast experience, not vast experience.
Yes.
But
your lordship may kindly say
there's the same issue relating to 2 or 3 lecturers of a particular college in Jajpur Road area.
Yes. Now your lordship may kindly see serial number 3, Sri S.K. Mahapatra.
Where are you reading from?
Page 76.
Yes, S.K. Mahapatra.
S.K. Mahapatra, the petitioner.
Yes.
He claims that EPF should be deducted from 21/12/92 instead of 28/12/94. And now your lordship may kindly see the last paragraph. In respect of Sri Saroj Kumar Mahapatra, who submits various documents stating that he joined the college with effect from 21/12/92, the documents relied upon and produced are resolution number 30 or resolution number 30 and 40. But so far as this order is concerned,
based on resolution 30 and 40.
Resolution number 30 and 40. Apart from it, well, this order is a nullity. Why I am saying nullity? Because this college is a category 1 college. The college received granted much prior to commencement of the Amendment Act of 1994, which has been admitted by the petitioner. You will also may kindly see paragraph 3 of the writ petition. That BNMA College Paliabindha in the district of Bhadrak was established in the year 1975 and got government concurrence and affiliation. And from Utkal University from session 77-78, the college has come into the fold of granted under direct payment scheme of the government from 1/6/83. Therefore, it is an aided educational institution within the meaning of section 3B of the Orissa Education Act. The institution is a category 1 institution as defined under the granted order 94. So far as aided colleges are concerned, but there is a separate rules.
Yes.
Meant for aided educational institution, that separate GPF rules. Your lordship may kindly see the manual, page 819. The Odisha Aided Educational Institutions Employee General Provident Fund Rules 1983.
This is page?
Page, same page, 819. 819.
819, yes.
My lord may kindly see rule 1. These rules.
So the EPF Act doesn't apply.
Does not apply in view of section 18. These rules may be called the Odisha Aided Educational Institutions Employee General Provident Fund Rules 1983. 2. They shall apply to all employees of aided educational institutions covered under direct payment system in the state. Now your lordship may kindly see section 18 of the EPF Act.
There is a bar.
There is a bar. My lord knows.
No, but still, then place it if you want to place it, place it. But I know, I'm looking at the watch.
Yes, your lordship may kindly come to section 16. Sorry, section 16. Act not to apply to certain establishment. I am placing 16B and 16C. To any other establishment belonging to or under the control of the central government or the state government and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. C. To any other establishment set up under any central, provincial or state act and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed under that act governing such benefits.
So basically your 1983 rules, since 1983 rules applies, EPF Act
is applicable in 2016. So far as block grant employees are concerned by framing a rules. Your lordship may kindly see that.
But how is it relevant?
Well, my lord, your lordship may kindly see when it was made applicable. When EPF Act was made applicable, your lordship may kindly see the rules. I have given in my additional affidavit, second additional affidavit.
Second additional affidavit.
Second additional affidavit. Good addition.
No, please place it.
Yes, your lordship may kindly come. Kindly come to annexure AB by 4. Page
This is 22nd November 2016.
22nd November 2016. And your lordship may kindly see Rule 2. Government
Yes.
means, your lordship may skip over that. Then your lordship may kindly come to B. Employee means the teaching and non-teaching employees of aided colleges, aided junior colleges, and aided higher secondary schools receiving block grant under the Orissa aided colleges, aided junior colleges, and aided higher secondary schools granted in order 2009. Odisha non-government colleges, junior colleges, and higher secondary schools granted in order 2008. And the Odisha non-government Upasastri and Sastri colleges granted in order 2009. 3. Applicability. The employees who have been employed in an aided educational institution prior to 31st May 2016 and covered under Clause B. Clause B, my lord has seen. Of Rule 2 shall be covered under the Employees Provident Fund and Miscellaneous Provisions Act 1952 as a social security measure. Then for how much contribution will be made, that is there. And this was also withdrawn under annexure AC by 4, page 8, with effect from 1/1/2018.
Yes.
So this is all. This is all about EPS. Now, my lord, my next point before your lordship is, since time is running out.
It has already run out.
Yes. My lord, now your lordship may kindly see the counter. My lord, he claims that he was appointed in 92. My lord, when he was appointed in 1992, he didn't have the requisite qualification. The requisite qualification in an affiliated college is 55%. Your lordship may kindly see that. Set the class.
You Mamata Mahathi.
No, Mamata Mahathi to asibo judgment. Your lordship may kindly see the circular. This is not available in that manual. Your lordship may kindly see.
Then you will have to file it.
Yes, I will file it.
You should secure 55%.
55%. 55%. Now you lordship may kindly see the counter. Counter filed by the governing body, your lordship.
Governing body means opposite party number 1. Governing body is opposite party number?
Opposite party number 3.
Yes.
My lord, may kindly come to annexure K by 3.
K by 3.
The mark sheet of the petitioner. He passed MA examination in 92, wherein out of total marks of 800, he has secured 421 marks, which comes to 52%. 52%. Then, my lord, page 35. He improved his percentage of marks in 1993, wherein out of 800, he secured 441 marks, which comes to 54. I am relying upon the judgment of the fellow Pramod Kumar. Your lordship may kindly see this judgment. That year 2008 Supreme Court 1817. I am just placing the placitum. If the essential educational qualification for recruitment to a post is not satisfied, ordinarily the same cannot be condoned. Such an act cannot be ratified. An appointment which is contrary to the statute.
I got.
Yes. And another judgment is Vatakrishna Adhikari. If initial appointment is bad, even if approval is made, that is also bad.
Please educate me. I think this the very point was decided in Mamata Mahathi also. That initial appointment.
Yes.
And then she was granted relief in the sense that.
Then recent judgment is, your lordship may kindly see the recent judgment.
That from the date of acquiring higher qualification, she may.
Your lordship may kindly see the recent judgment. Once appointment is declared illegal and void ab initio, one cannot legally continue in service and claim salary.
But that will be for the period of which he has not.
Yes. Then my next point before your lordships is, he accepted the position. I have shown the approval order. And he accepted his date of appointment as 94.
He never challenged the approval order.
Approval order he has never challenged. So all the three persons, Tapan Kumar Naik, Mrityunjay Narayan Das and the present petitioner,
Yes.
they accepted the position. They not only received grantinate in terms of the grantinate order of 2009, but also they received grantinate in accordance with the grantinate order of 2017.
Yes.
17, your lordship may kindly see, I have given that in my second additional affidavit. My lord, may kindly come to annexure AD/4. এটা 2017 রে গ্রান্টিনেটটা পাইলে। Now he has manufactured a document by saying that he has objected to this, although nothing was filed. Annexure AD/4. My lord, may kindly come to page 11. Serial number 7, Saroj Kumar Mahapatra, third post.
Yes.
Here date of appointment is not there. Date of appointment is there in the first order, 2009 order. And scope of judicial review is concerned. But I have brought two judgments. Your lordship knows about it.
So that's all.
Yes.
And Mr. Das is not there. I had granted him 5 minutes. We'll take it up tomorrow. All right. Arguments completed. Heard further arguments. Sri K. Swai concludes his argument. Let's this matter tomorrow for hearing arguments from the side of the petitioner. For hearing reply. For reply. Achha, you wanted to. What is your view?
All the points are covered.
All right. What is your good name?
Swapnil Roy.
Also heard Sri Swapnil Roy, learned counsel appearing for the governing body, bracket opposite party number 3. So, let's this matter tomorrow for reply by learned counsel for the petitioner. Yes. The problem is, it will be difficult to give a judgment before vacation.
Before vacation.
Item number 11.
May I please, my lords?
Yes.
The last occasion, my learned senior, Mr. Patnaik, my lord, was appearing for the
Original resolution book. Yes. Yes, Mr. Patel. You wanted some time last time. Yes. I granted you time.
Yes, only I have time for after lunch.
After lunch, no, after lunch. After lunch, bail matters are there. So
let us conclude it, my lords. We have already filed a note of and your lordship will keep the records and pass orders. My lord, this has been going on, my lord, for innumerable times.
I'm sorry. What he says is correct, but because of something which is unexpected, because of my illness.
that's all. Mr. Patel, I have also granted you leave. It's not that I have not granted you time. I have granted you time. Last time,
Not on time. Only I have time after lunch.
after lunch, there is a bail matter. So I will. The problem with is the bail matters also have to be taken up. So we can take it up tomorrow.
Tomorrow.
Mr. Koram?
Tomorrow.
As requested by Sri B.K. Patnaik, learned counsel appearing for the management. Let's this matter tomorrow. Please be ready tomorrow. We may not conclude it. If it is not difficult, we will adjourn it. But all right. Item 12.
Let's say now the present petitioner now is a retired person. The question of recovery was under challenge. Your lordship has taken up the matter on several dates.
So that interest matter.
That interest matter. The governing body last date filed an affidavit giving a go by to all their pleas. Now they are saying that they are entitled to recover 10,000 some odd rupees from the petitioner. 11,000 some odd.
11,473.
Today, last date, that is their stand. But I took instruction on that. My client has given instruction with reference to the bank account that the whole amount is recovered, not even 11,000. They have also recovered that 11,000. It's not due on the statement I'm giving to my learned friend today, because yesterday we got this statement.
You also have to file a statement today? No, file
file. I think my learned friend should carefully
Statement which the petitioner has annexed, my lord. How he got that statement, college record, it is a college record.
ଛାଡ଼ନ୍ତୁ ମୁଁ ଆଜ୍ଞା ସେ କଲେଜ ଲୋକ ରିଟାୟାର୍ଡ ଲୋକ କୋଉଠୁ ଆଣିଲେ କଣ ସେ ପାଇବାର କଥା ଯଦି ତାଙ୍କୁ ଦିଅନ୍ତୁ
ଆମେ ପାଇବୁ କଲେଜ ପାଇବୁ ଇଣ୍ଟରେଷ୍ଟ ପାର୍ଟ ଟା ଆମେ
ଯଦି ଆପଣ 11,000 କହୁଛନ୍ତି but Mr. Ratha says that the entire amount has been recovered including the interest which was calculated probably twice.
ଟୋଟାଲ
ଆମେ ବ୍ୟାଙ୍କ ସବୁ ଦେଇଛୁ।
ଶୁଣନ୍ତୁ ଆଜ୍ଞା so come out with a definite instruction. Take this and
I have filed specific affidavit to that effect.
so you can argue today on this basis. It will be better because
I will take instruction on that
obviously
document.
And this plea that where he got the records, well, normally I also ask that question. In many cases, I've asked that question, which has caused embarrassment to the concerned counsel. But here, there is a question of a retired employee. 10,000, 11,000 टंकार कथा. Shri Ratha, Learned Counsel for the Learned Senior Counsel. Who is assisting you?
Mr. Behera, Adhiraj Behera.
Shri Adhiraj Behera, Learned Counsel appearing for the petitioner files a reply to the affidavit filed by the management after serving copy on Shri Raiguru. Stop. Shri Raiguru wants to take instructions in this regard. List this matter. Date karo. Reopening date?
18th June.
On 18th June. The parties are requested to come ready.
Yes.
18th, 19th or reopening টা
Reopening ro kono?
case বহুত দূর
Parties are requested to come ready for final disposal. Yes.
Interim order to continue.
Interim order to continue.
Item 13. Yeah, people options. Still option that one better an extension. The present petitioner is challenging annexure 3.
Just a minute, let me read the previous order.
Right.
Yes, submits that said Pragyanani Ponda is no longer continuing, having been terminated. As this court finds no reason to impede Pragyanani Ponda as party. Opposite party number 5, namely Augusti Sunani, is continuing against the termination vacancy caused by the termination, whose petition is taken up for hearing. Okay. You are the petitioner.
My lord.
Yes.
I'm challenging annexure 3 as the order of director. Against the order of termination, I have approached to the director under the resolution. Now he has rejected my claim. I was initially appointed as a lecturer in political science. Thereafter, I have continued as such. Now, pursuant to that, they have prevented me from discharging duty, against which I have preferred an appeal with the director. In 2009, when the appeal was pending, the director didn't take up the matter. So I put this honorable court. This honorable court disposed of the writ application, directing the director to expeditiously hear the matter. Pursuant to that, answer 3 has been passed, Your Lordship. And the director has proceeded only on the single aspect that the very appointment of mine was a forced one. I was never appointed in the institution. That was the entire case of the governing body before the director. I'll just place that order, Your Lordship. Page number 19, annexure 3.
Come to the last paragraph.
My Lordship. The case of the appellant. The case of the appellant in the appeal petition is that he was appointed by the governing body of the college by office order number 20 dated 15/5/1987 as a lecturer in political science. He joined the post on dated 16/5/1987, which was accepted by the secretary governing body. He continued in his post till the end of the year 2007-2008, and after that, when he entered into the college campus to discharge his normal duties, secretary governing body prevented him from entering into the college. During the course of hearing, the governing body represented through his secretary submitted the original GB resolution book, attendance register, equities roll, and dispatch register to ascertain the validity of the appointment of the appellant and his continuance in the college. The advocate appearing for the governing body submitted written note of submission on 24/6/11 as directed. Heard the matter, perused the relevant documents produced by the secretary governing body, and written note of submission filed by the advocate appearing for the governing body. The stand of defense of the governing body in this instant appeal petition is that the appointment order dated so-and-so as enclosed by the appellant claiming to have been appointed as lecturer in political science as by resolution dated so-and-so is a false and fabricated document on the ground that the so-called appointment order was issued prior to the passing of the so-called resolution. It has also been stated that there is no resolution of the governing body in appointing the appellant as lecturer, and so also no appointment order has been issued for which the question of allegation regarding obstruction prevention to the appellant does not arise. Rather, the case of the appellant is a false and concocted story. Considering and examining all the materials and records, I arrived at a conclusion that the appointment order which the plaintiff has relied upon and annexed as Annexure 1 is a forced one. The so-called appointment order cannot be issued before passing necessary resolution by the governing body. In this instant case, the appointment order is on so and so date, and the resolution is on so and so date. The resolution also does not disclose anything about the appointment of the appellant. In view of the above position, when the initial document required for a service is a forced one, it will be just and proper to reject the claim of the appellant, and the appeal is hereby rejected for the end of justice. So the entire case of the governing body before the director was that I was never appointed in the institution, and the appointment order which I have produced is a false and forced one, because there's an overlapping of the GB resolution and my date of appointment. I will produce a document here. So I've included Annexure 1. I've included a document at page number 12. There's an overlapping. I do admit, your lordship, because according to my appointment order, I was appointed on 15th of 1987, and the GB resolution has been passed on 2/8/1987, which could not have been mentioned in that appointment order. But my learned senior has filed a counter affidavit. In the counter affidavit, they have admitted that I was appointed and I was discharging my duty.
Where is it?
It's at page number 9. Look at the counter affidavit, your lordship. Annexure A by 4 series.
Yes.
They have annexed by actual appointment. Now they admitted I have been appointed, but before the director, the entire case was I was never appointed, and the appointment order which I have produced is a false and fabricated one.
You produced your reply before the director. You must have given a reply, a counter before the director. Some written submissions must have been given by the governing body. You produce it, or we'll call for the file.
You also may call for the file.
I'll call for the file because you see, ordinarily, this being a finding of fact,
Yes.
this court would be slow to interfere. Unless he says that it's a perverse finding, which though he is not saying in so many words, he is hinting at that.
Yeah.
The finding is wrong.
One thing I may.
Yes, Mr. Pradhan.
Its initial initial appointment is a void, your lordship. Just your lordship held that.
You have given this A by 3.
Right. I am submitting, Lord.
To keep that in mind before submitting.
Yes. I have some keeping that in mind. I am submitting, Lord. What happened? As per advertise, he applied and he was got appointment. But at that time, Lord, he was continuous elected member of a Panchayat Samiti.
That's why last time you had taken that.
Yes.
But where is that plea you have taken? If you have not taken that plea earlier, now is it open to you to take this plea now?
No, say the Katha, your lordship is very much right. Your lordship is very much right. The lordship may call for the record.
That is what I would like to see. You have filed an IA.
Yes, sir.
IA is not necessary.
For that purpose, we call you that.
IA ko 58.
The IA number is
To produce the records. Already. IA 5899 of 2024. After hearing the counsel for the parties at length, this court is of the view that the records of the proceeding before the director case record.
Appeal case number.
See case number ta kite jane
Appeal the case tanga number nath hai.
bere number hue
appeal case. It's
Tanga number nath hai.
Order number.
order number.
This is called relating to office order number 34219 dated 10/8/2011 for perusal of this court. Leonard State Council is directed to do the needful. List this matter.
18th, my lord. 18th June.
Reopening day? Yes, Mr. Mishra.
PH category, madam.
5 seats.
5 seats per PH category, and 2 is PH OS category, 2 is PH VI category, and 1 is PH HI category, hearing impartment. The present petition, my lord, the merit list and selection list has published. Merit list and provisional modesty and final ministry provision 22/10/2013, man. Where the present petition stood third position. Where the Achyutanand Samal and Ranjan Kumar Das is first and second position. Both are rejected, madam. Due to the 10% result in Achyutanand and 2 is double candidature.
Yours is
Therefore, I am the
40%.
first.
Yours is 40%.
40%. Therefore, I am the first. But my name was not sent to the medical board due to the ban order has been issued. The only plea that ban order is issued.
What ban order?
Ban order, the finance department issued letter by the director, the 16/12/2013, no further engagement. No, therefore my name was not sent. But thereafter, in my thereafter, 24 you had 24/1/2014 manner. That is 16/12/2000 is ban applied. 24 DO Chandrapura cancelled the candidature of 21 candidates, including Ranjan to others, and 28 5% of PS category sent for re-examination of medical board. Thereafter, man. And once Surendra Behra received from medical board is 24 and including the Satapadma Pradhan Mara. Satapadma is not in provisional list. The plea even raised by the government was that my name was not provisional list. Therefore, I am in third position. But subsequently, I am first one. My name was Satapadma also not in provisional list, but he was sent on 28/14. His name, her name was sent to the re-examination of medical board. Man. And I am given a application before the collector and the director matter for consideration of my case, but no consideration was done. Therefore, I filed before the State Commissioner for Disability. And lastly, the order was passed matter. In this case, the court has held that subsequently another plea raised by the government was that the interchange between the PS categories. Because as per the provision of the PSD Act matter, I am clarified that after the section 36 matter. Vacancy not filled up to be carried forward. Where in any recruitment year, any vacancy under section 33 cannot be filled up due to non-availability of a suitable person with a disability or for any other sufficient reason. Such vacancy shall be carried forward in the succeeding recruitment year, and if in the succeeding recruitment year also suitable person with disability is not available, it may first be filled by interchanging among the three categories only when there is no person with disability available for the post in that year. Interchanging question is raised when second recruitment year, not first recruitment year. In the first recruitment, that is the specific reservation in post of the TGT Art, ACBC, and PS category for OS category matter. But the DO Chandrapura has interchanged the same. They take a decision and interchange same, and it is shifted to VI category and upon in Sanskrit matter, in stream of Sanskrit. But I am in Sanskrit TGT Arts matter. That is the plea raised by the government. It is two pleas raised by the government mainly. That is the ban order, and second is the interchanging that for no discrimination. But it is first recruitment year, that is no chance of recruitment. That's what the provision matter. That is second year. If it is not suitable,
That point is taken, Mr. Rao. Why are you repeating?
Yes.
I don't understand.
Yes, ma'am. And that plea was taken by the State Commission's matter. And I am reading page 18. The interchanging vacancy of Sanskrit TGT Arts as mentioned in para 12 of the source affidavit not reasonable as B2 of the source that the DO Chandrapura for provision of final merit list and provisional merit list is mentioned in the provisional select list has been prepared as a roster computation prescribed the government. Geo number 24 bar there bar in the provisional select list of PS category. Such source is indicated that one PS which cat under ACBC has been reserved for TGT Arts. Such reservation was based on the roster, and as against that post, Achyutan Samuel was selected. And Achyutan was rejected due to 10% disability. Thereafter, Rajan Das was double challenge. And the vacancy not filled by the carried forward, I have already read matter. In the provision stated that the vacancy shall be carried forward the succeeding recruitment year in any one of the event where there is a non-available to a particular category person with disability candidates of any such post, where there is a sufficient reason for not filling the vacancy. Thus, it is crystal clear from the above provision that interchanging in the first year of the recruitment cannot be contemplated. That is page 19 of the order matter. In present case, post of the contract is a TGT Even the Achyutanand Samal was found not suitable for having 10% disability and Ranjan Kumar was disqualified due to the double candidature.
All right, Mr. Raut,
Yes, madam.
I've heard I have considered your, so it all depends on the acceptability of the judgment of the ACPD. So let them place it. We'll go to your writ petition. Though the order is the same.
Yes.
The first, the facts are admitted. The first person, Achyutananda Samal, had 10% disability.
No, madam. May I be permitted to
Please,
place?
please. No, but that is what here.
I will take your lordship from that particular order itself.
Yes,
What we have admitted and that has been taken care of, madam.
yes,
That is in the first phase. And it is.
of your writ application.
No, in his writ application, madam, 1371 of 2018,
Okay,
the order, madam.
okay.
Look, page second page.
କୁହନ୍ତୁ ମୁଁ ଅଛି ମୁଁ ଦେଖୁଛି
Say,
page 16.
So, that it starts with page number 16, my lord, 17/2015 order. My lord, the last para.
15.
There was specific time frame.
No, my lord, I think my lord, the previous page. My lord, actually, if it not
Okay,
been.
okay.
The DEO Kendrapada.
Yes, yes.
The DEO Kendrapada admitted the rejection of the candidature as there were 5 posts reserved for PWD distributing, 2 posts for locomotor disability, that is 1 each in TGT arts and Hindi stream, 2 posts for visual impaired distributing 1 each in TGT arts and classical Sanskrit, and 1 post of hearing impaired in TG arts stream. As against 1 post of locomotor disability of TG arts, Achyutananda Samal and Ranjan Kumar Das were selected. That the complainant claims her engagement against such 1 reserved post for locomotor disability, that the said Achyutanand Samal, who stood first in the merit list, was referred to the appellate medical board, appellate board, my lord. Because that my lord, before any appointment is to be given, my lord, they are to be referred once again, my lord. Similarly, my lord, in case of the petition also, my lord, she has to be referred to the appellate board. If he or she is stood first, my lord, in that one, and who stood first in the merit list was referred to the appellate board and at SU Medical College, Kotak, for verification of his disability, but his disability was found 10%.
That is what I'm saying, 10%.
At that time, my lord.
Anyway, at that
he was offered. Then, my lord, the question of second candidate, Ranjan Kumar Das, placed in the locomotor disability category, but he was disqualified. Then the second category due to double candidature.
Yes.
That while the re-examination of the disability of 5 PWD candidates, as mentioned in para number 6, in so cause dated 14/11/2014 of respondent number 2 was pending before the appellate medical board, the Director of Secondary Education Odisha, dated 11/12/2013, banned further engagement from the panel with effect on 16/12/2013. In the monthly video conference, it was clarified that only referred cases can be acted upon after the dated 16/12/2013.
What is the meaning of this?
My lord, in fact, my lord, there was a time limit. But when the selection process was different district authorities, my lord, they continued the selection process beyond that particular period. Thereafter, my lord, the director put a cut-off date that whatever you want to do, beyond that, it is not permissible. Then, my lord, that is the cut-off date with a further rider. If in the meantime, anything has already been referred to the board, medical board, my lord, then their cases are to be considered. But no fresh case will be considered. So, to this extent, my lord.
Keep this in mind to answer me subsequently, because the question strikes my mind immediately. Could you have done that? Fixing a cutoff date after the selection process had been initiated?
No, the process of initiate.
It's not a question of, we are not talking about the validity of a select list already produced.
My lord, here, what
Already prepared rather.
Yes, ma'am.
What I'm trying to.
Normally, it should not have been, my lord.
So how could he subsequently introduce a cutoff date, saying that
No.
beyond that you cannot.
When the selection process was allowed to continue by the different district authorities beyond the last date.
Okay, all right, all right.
That is what, my lord, it has been decided by the commission that once you took a decision at your level and there was a delay on your part, then why this particular petition will be suffered. That is what it has been decided.
Right.
Ultimately, my lord, that is the finding. So, my lord, fact is this much, my lord, that there was no stream-wise vacancies, my lord.
No, but as it appears, it is because of this introduction of a cutoff date
Yes.
the candidature of the petitioner was not considered.
Yes, madam. Ultimately, my lord, that is the final.
So it boils down to, that is the crux of the point.
But my lord, this cut-off date, my lord, it is not, it is beyond the date what it was declared as a cut-off date in the original select list, original selection process, madam. During the process of selection, there was a cut-off date. But beyond that, my lord, when the district authorities were continuing that particular process of selection, the director put up a cut-off date. So it is not that, my lord, putting a
We will
cut-off
go to
date
those
before that.
documents. We will go to those documents.
Before that, madam. Yes.
We will have to go to those
Well,
documents.
one thing, my lord, I have also gone through that, my lord. One thing. There, my lord, while putting that particular cut-off date, the language is like this, my lord. If your lordship will come to my counter, my lord, in this case,
Yes.
that is, my lord, it is a pen note 24, annexure F/2. That is what we are referring to.
In this, there is a counter affidavit by opposite party number 3.
Opposite, yes, my lord.
There is running page 59. madam. In Annex India chart, madam. Running page 59, page 124.
That is 11/12/2013 letter, my lord.
I am unable to get it. Annexure A/3.
F/2, my lord.
A/2
Well,
nice.
what happened, my lord? In fact, this is the document.
Sir, I am not getting it. I only have counter affidavit filed by opposite party number 3. Only 3 annexures.
That page 24, madam. And in Annex counter affidavit, page 24, 55.
Yes, well, counter opposite filed by the opposite but now 3. But enclosing the show cause affidavit, which was filed before the commission. There, my lord, this particular document was a part of the
All right, yes. 11/12/2013.
11/12/2013.
Yes.
That is the cut-off date, my lord.
Yes.
That ban. May I permit it to read?
Yes,
my lord?
please.
Inviting a reference on the subject cited above, noted above, I am directed to say that as per the calendar prescribed by directorate letter under reference, the engagement process of contract teacher in government high schools, including upgraded high schools, during 2013-14 might have been completed in the meanwhile, but no final report has been received from you till date. To all the DOs, my lord. Therefore, you are requested to complete the engagement proposal by 16/12/2013 positively and furnish the on-field contractual vacancies out of the contractual teacher post advertised during 2013-14 in the enclosed pro forma so as to reach the undersigned by 18/12/2013 positively for onward transmission to government. There will be no engagement beyond 16/12/2013 in any circumstances. Further, the said on-field vacancies provided by you will not be filled up later without prior permission of the director. So, my lord, here the calendar which has been stipulated, my lord, which was stipulated at the time of selection process. Because the district authorities were continuing that particular process beyond that. That is why, my lord, a cut-off date was issued. It is not, my lord, in the midst of the selection process, a cut-off date has been issued. That is the first thing. Second thing, my lord, here
No,
there
but
is also-
Mr. Patnaik,
Yes.
coming to this very point,
Yes.
if the delay is attributable to the authorities themselves,
That is what, my lord, the commission has found.
then
My lord,
how can the candidates be? It's after all a question of livelihood, and this particular person was placed in the select list, provisional. When the first 2 persons, for whatever reason, they were not selected, so a candidate was available, he was not considered. The delay occurred at your end, and subsequently you introduce this cut-off date and say that he can't be considered.
my lord, in this case, my lord, another point has been taken,
Yes,
including this delay part.
and their ban.
Now, this is the ban.
Hmm.
And, my lord, what it has been observed by commission, my lord, that the authorities have prescribed a time limit of the different actions to be taken in detail. And that is the calendar, what we refer to. When there was a delay by the authorities themselves in comparison to the calendar what they have prescribed, then putting this particular cut-off date and not filling that particular post by the petitioner, that is not correct. That is right. But simultaneously, my lord, it is our another stand that these vacancies have
these were not actually distributed stream-wise, my lord. So it is not possible. Otherwise, my lord, one person will get a particular post in the art stream, otherwise another person will never get. So even if a more eligible candidate is available in Hindi stream, he will not be eligible to get that category benefit, my lord, PS benefit. So it is not in the stream wise. So what we have stated, my lord, in our counter, that the petitioner has secured certain mark, my lord. In comparison to her mark, the person who is the person in the same category in the Sanskrit stream, my lord, he is more closer to that particular year. No,
He is also a physically disabled candidate.
yes. So it is not that we had prepared, my lord, in that particular category, number 1, number 2, number 3. But taking into consideration the marks secured by them, we actually verified their candidatures. When we took up the first one and sent him to the appellate board, my lord, he was
You
disqualified.
file a rejoinder, Mr. Raut.
Already filed, my lord.
Where
I will answer this question.
Where is the rejoinder?
Reason is there, my lord. I have answered all the points, my lord. My lord, the grievance raised by the
All right. Then conclude.
Yes, ma'am.
the grievance raised by the interchanging.
It is not a question of interchanging, my lord. From the very beginning, we are saying that we have not made it stream wise. So if there was a question of filling the post, my lord, in stream wise, there is a question of interchanging. Since we have decided not to fill it up on stream wise, so there was absolutely no scope to interchange, my lord, from one category to another category. And interchange means, my lord, that is with respect to the different categories. That concept, my lord, what it is there in the statute, my lord. My lord, there are different categories: hearing impaired, locomotor disability. So because there are certain percentages in respect of each categories, so my lord, and there are defined posts, my lord. So for them, my lord, there is a question of interchange. But here, my lord, stream wise there was nothing. So my lord, what we have stated, my lord, there is a specific stand what we have taken, my lord, in our counter. Yes. My lord, it is in para number 12, running for 6, my lord. It's a continuation of running para number 12. Therefore, as for the my lord, we have stated, my lord, in the I will read, my lord, from para number 12. That is only submitted that the selection of PH candidate in Kendrapur district has not been done stream wise, and it is a fact that the total number of candidates whose name found place in the provisional select list being limited to 64 in 6 streams. It would not have been possible to give justice to all categories of the PH candidate in all streams. Therefore, as for the decision of the district selection committee, computation of PH vacancies has always been made, taking together the posts of all the streams and then dividing that subcategory wise within the PH category. At the time of identifying subcategory wise PH reservation, it is always attempted to put the person with highest percentage of mark in close proximity of normal selection, so that others do not feel discriminated. In the instant case, if the panel would have not been banned in directorate letter dated 11/12/2013 and Achyutananda Samal declared ineligible by the Appellate Medical Board under PHOH quota, the district would have opted to change the stream to Sanskrit because the PHOH candidate available in Sanskrit is more near to the cutoff mark. At the time of deciding the stream by the district selection committee, it is also what PH representation is already available in that particular stream.
Where is the advertisement? This particular method of selection, that stream wise vacancy or not stream wise vacancy, where do you get it?
It is the selection process, my lord, what they had adopted.
Where is that selection
uniformly.
process? It must be based on some.
Yes.
What he has said, you can't explain, you can't improve upon your case in the counter, isn't it? So there must be some material.
No, what they
Some
had done, my
justification.
lord, during the selection process, they had explained it.
No, but that must be on some rational
Yes, ma'am.
basis.
Of course.
That has to be on some rational basis.
So whether this particular
You
guideline,
take further instructions, we'll take it up after.
yes,
occasion.
my lord, to that, my lord, the procedure, what it has been adopted during the selection process, whether it is codified somewhere.
Heard further arguments in part, stop. In course of hearing, attention of this court is drawn by learned state counsel to the amendments made in paragraph 12 of the counter affidavit, wherein the procedure adopted for selection of PH candidates of Kendrapada district has been delineated. This court would like to know the basis for adopting such selection procedure. So, learned state counsel shall address the court on this issue. Place this matter on
2nd July.
2nd July.
Yes.
Yes. এটা এই ফার্স্ট রিট অ্যাপ্লিকেশনটা করব আরেকটা খালি তার সঙ্গে আসবো
সেটা স্যার আছে।
ইয়েস
Item number 15.
Last occasion, opposite party number 5 appeared and submitted the transfer certificate.
you files a copy of the transfer certificate issued by the headmaster Nigamananda Bidhan and be kept in little copy of
Another certificate was also sought for birth certificate, not submitted.
where is he who is appearing
With,
asu vacation for asu okay Mr. Mishra
Suresh Prasad,
let it come after vacation
only one point. This
hele se nahadi to final kori hoboni I am willing to take it. I am
serve the entire rejoinder and additional affidavit on the same date to your lordship direct.
Sri A.K. Mishra, learned counsel of the petitioner is present. He submits, comma, as directed, copies of the rejoinder and additional affidavit filed by him have been served upon learned counsel for the opposite party number 4.
5.
Sorry, opposite party number 5. There is no appearance from the side of opposite party number 5. Place this matter on 18th June. On that day, we'll complete it.
Item number 16.
Pursuant to your lordship's direction, mediation
going on.
process is
Diya
going.
lage ekati koyi hogi. Tikhe bahut kohun pare. Kon mediation proceeding ro kon hala.
It is still going on.
17th.
Another date has
The
been.
report of the mediator indicates that the next date fixed for mediation is 17th of May. Hence, list this matter. Vacation pare asu obviously.
State.
Vacation pare asu state kar do. Besto kon.
Adjournment and
Adjournment petition, right?
court below.
List this matter on 18th June. In the meantime, if any application is moved on behalf of the petitioner in the court below seeking adjournment, comma, the same shall be considered having regard to the date fixed for hearing of this case.
I am the petitioner in TRPC number 412 contact.
Chitra kon achi? Chitra seମିତି order
Both
ହେଇଥିଲା?
cases are there.
Chitra same order କରିଦିଅ? Yes.
Item number 17.
Yes.
May I please, your lordship? My lordship, I'm on behalf of Mr. Sundar Rai. He is unable to attend the court today, so I'm seeking an adjournment for
Yes. What is this matter about?
My lordship, matter is about a transfer petition.
Where is your file?
My lordship,
Where is your brief? Why are you appearing before the court without holding a brief?
my lordship is unable to give me.
No. I'm asking you one question. Answer me. Where is your brief? Without the brief, why are you making a submission before the court?
Pardon, my lordship, I'm extremely.
No. This is very wrong. How do you know that the court will? You have taken it for granted that the court will grant you an adjournment. I will not grant you an adjournment. I'm asking you to place this matter.
My lordship, his father was unfortunately demised.
Maybe.
Sorry.
I'm not asking him to appear. I'm asking you are before me. You argue the case. Argue the case. Get ready. Where is your file?
I don't have.
You don't even have the file. You're very wrong. How long have you been practicing?
My lordship, it's 2 years.
2 years. 2 years is a long time. And this, you are an officer of this court. Your job is to assess the court, but you are not even holding the brief.
My lordship, I'm pardoned for that. I apologize for that.
What is your name?
Janamani Jivan Jyoti.
Janamani
Jivan Jyoti.
Jivan Jyoti. Ms. Janamani Jivan Jyoti appears on behalf of Sri Deepak Ranjan Sundarai.
My lordship, interim order is also there.
Ruvatu and seeks adjournment on the ground of personal difficulty of Sri Sundarai. Adjournment is granted on the condition that on the next date, Ms. Janamani shall address the court. Otherwise, I'll vacate the interim order. What is the interim order?
Shiva, I'm not going to do this. I'm not going. My lordship, on the next date, I will be here.
Already interim order shall continue till the next date. Huh? Place this matter on 18th June. Yes.
Item 18. Item 18 pass over.
Pass over. Pass over vacation for us. Who's appearing for the other side? You are appearing.
Mandate.
We'll take it up after vacation. Kौन इसी तरह? कौन order कौन इतना? Application is. I'll grant you that the same order I'll grant you. Interim order. You can seek adjournment.
But there is an interim order.
Yes, that if any application for adjournment is moved, that will be considered. Yes.
Since 2020.
These are 2024 matter. What?
Since 2020, he is not paying a single fire to the wife and daughter.
Hey, there he is, Mr. Banjadov. Yes, Mr. Banjadov. There is no chance of any settlement.
Yes, my lord.
Settlement,
There is. I am ready for settlement. So I pray for one time. I am ready for settlement for dispute, my lord. Lordship may also send for mediation center. There is a settlement also going on.
What do you say, Mr. Pradhan?
It is settled. Settle final settlement. Lordship may also
First deposit 1 lakh rupees, then I will send it to settlement. Yes, show your bona fides.
We have last occasion deposited the court below, man.
No, not a single.
I have given as for instruction.
Today I have obtained instruction for a single pie. They have paid.
I'll call it tomorrow. You produce proof of deposit being made before the court below. जहाँ पर दीजिए
So my lord, RTG share dates.
No, ठीक ଅଛି. So
Again, family court judge insist kale March first jolly cholibe ki 2000 masar alga hai ki ache pay ye delani
credit come tomorrow.
police station re debi badhya hoy ki sei masar 15000 tanga had cash jai ki adhana bhitar bahar kari dabar se chadile family court judge
पैसा ଦେଇଛନ୍ତି କିନ୍ତୁ ଲକ୍ଷ୍ୟ I am for the full settlement date ହେଲେ ମୁଁ ଇଏ କରିଦେବି.
No. You give some amount, further amount, I will send it to mediation. You prove your bona fides. This is a question of maintenance. It is not just a question of divorce application. You prove your bona fides. If you are so much interested in settlement, pay some amount towards maintenance. She is your wife after all, your wife and child. You are not paying it to some outsider.
My respectful submission is there. In my lord, I have filed a divorce petition Burger.
Maybe.
We have also maintenance award has been filed. She has also appeared. Here in this case, he has filed 125 procedure. So award has also marriage took place on that place. So I prefer transfer, but I also want to settle.
Yes. So that is. I am very good. That I am very happy that you are intending to settle the matter. Please pay some amount.
He's staying at Bangalore. मतलब समय I will.
Bangalore टोका ऐसे वो कैसे लगे बोले अपना बोलते हैं? ये जो आगो का तारों रास पर से तारों रास में चली. आगो कौन पहुँचे नहीं?
I'm also ready for final settlement.
No, I'm calling it tomorrow. You deposit some amount.
Monday.
Not Monday. I'll call it on Friday. Yes, Mr. Pradhan, I'm calling it on Friday. Sri S.K. Banjadeva, learned counsel appearing for the petitioner, submits that his client is ready for settlement. This court would like to know. Sri B.P. Pradhan, learned counsel appearing for the opposite party wife, submits that the petitioner has not paid any amount towards maintenance. Stop. List this matter on 17th may learned counsel for the petitioner shall obtain instructions from his client as regards the amount, that he would pay towards maintenance. Whereupon the submission regarding the possible settlement of the dispute between the parties can be considered. Ask your discussion. No. No. Okay, sir. Imprimatur, you continue till that. Ask your client to pay some amount, substantial amount. Then I will refer it to mediation. Yes.
Item 19.
May I please, Your Lordship? My lord, I am in virtual mode, my lord.
19
I
on
am for
behalf
the
of
opposite-
Mr.
I am for the opposite party, Your Lordship.
Hmm.
My lord, kindly take up the matter after mediation, Your Lordship.
The mediation center को जाइथिला कोन होईची?
My lord,
Mediation
My lord,
center,
a coordinate bench of this honorable court has referred the matter to the mediation
Yes.
center, Jagsingpur, my lord.
That is what I am asking.
In a criminal miscase. And the matter was in that CLMC was taken up on 9th, adjourned to 25th, 7th, awaiting the report, my lord. So I pray let this matter be taken up after vacation so that by that time mediation will talk.
It is submitted that
On behalf
mediation.
of Mr. Biswaranjan Das, my lord.
It is submitted that the mediation proceeding has not concluded as yet. Therefore, list this matter
16th July, sir.
Huh?
16th July.
on 16th July. What was any interim order was passed?
Interim order is there.
Well, interim order to continue.
oblige, Your Lordship.
Item 20, yes, Mr. Mishra. We did not back.
I am for the wife.
Postal tracking report. What does it say? पीछे ऐसे नहीं.
Packing report
Tracking report is inconclusive. Take fresh notice. The postal tracking report is inconclusive as regards service of notice. Hence issue fresh notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow. List this matter on
July, sir.
2nd July. Same interim order जाता है. In the meantime, if any application for adjournment होता है, ना?
Item 21.
I am for the petitioner lordship. The opposite party husband has already appeared. I am for the petitioner wife. The transfer petition has been filed to transfer the CP proceedings. Civil
Settlement, any chance of settlement?
Your Lordship, I am for the OP.
Yes, that's what I'm asking. Any chance of settlement?
Actually, we want some time to file objections.
No, objection you may file provided there is no chance of settlement. Is there any chance of settlement? I'm asking.
Sir, actually, we have applied for under section 9 for restitution of.
So you should be ready for settlement.
Yes, we want for reunion.
What do you say?
Thereafter, the FIR has been lost. Last occasion I have submitted.
Those things, these things happen in matrimonial matters. FIRs are lodged and everything. Many allegations are made. Even at this stage of Supreme Court, also the matter can be settled. So there is always a possibility. Nobody is forcing you.
Yes.
If you want, I can refer it to mediation.
Bismillah. But the lower court, the short date is fixed.
No, that we will stay. That we will stay.
Yes.
All right. In course of hearing, it is stated that it is submitted that the nature of dispute between the parties is such as can be settled amicably through the process of mediation. Hence, I'll send it to High Court Mediation Center.
Yes.
Parties are from which place?
Just.
Then
we are from Kendra.
Well, then they can come to Cuttack, no problem.
No, actually, sir, actually, we want a neutral place because
Cuttack is not a neutral place.
Jajpur, he has a rate for Kendrapada.
I'm filing for a transfer petition. Therefore, mediation center, High Court will be.
Okay.
Yeah.
Okay. Let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to act upon receipt of notice from the mediator and to render full cooperation in the mediation proceeding. Lest this matter
16th July.
on 16 July. In the meantime, further proceeding in CP number 394 of 2023, pending in the Court of Learned Judge, Family Court Jajpur, shall remain stayed till the next date. In the meantime,
Obliged.
Item 22.
22, yes, Mr. Das, what were you saying?
Well, 22 days, I instead of the speed post requisite, I have filed the rest post with AD. That may be accepted.
No. Why? This amounts to a violation of the court's order.
I oblige me.
And then I would like to recall my order. Why should I do all these things? Why will your client not comply with the order?
Wrongly, se suni parna tha am clerk ji file kar diye. Ani parna.
I will not
repeat this mistake.
No, I will not pass any comments on the efficiency of your clerk and the extreme competence of your clerk. But Mr. Das, this is not done.
This is
In transfer matters, I am issuing notice through the speed post mode.
se mu pachali order ta upload hobe to late.
TKC Das, Learned Counsel appearing for the petitioner, submits that inadvertently requisites for issue of notice through registered post have been filed. He requests for accepting the same. Considering the submissions, the requisites file be accepted. A short returnable date be fixed. List this matter on
9th July.
9 July. In the meantime, if any applications, we would ask sit about them. Yes.
Item 23.
Despite notice, no response is filed by parties, opposite parties. The matter related to ASA, recognition of ASA.
Yes, Mr. Tripathi is to appear.
Yes, Tripathi.
We are appearing on behalf of OP number 2 for Mr. BP Tripathi, my lord.
All right.
CDMO is authorized, my lord. They will file the reply.
What's your good name, sir?
D. Patnaik.
Sri D. Patnaik appears on behalf of Sri BP Tripathi, Learned Counsel for the NHM, and submits, the CDMO has been authorized to file affidavit in this case, which is being prepared. So he requests for an adjournment. List this matter
9th July.
on 9 July. Counter affidavit, if any, be filed in the meantime.
Item
Obliged.
24.
Interview order to continue.
It's in order to continue.
Please, your lordship.
Yes.
Lords, here I have challenged an order framing charges. Your lordship was pleased to issue notice and the interim orders were passed also.
Yes.
Now I have filed a petition for modification of that interim order. In essence, it's a petition to vacate the interim orders.
You have taken this interim order.
Yes.
You wanted to be vacated.
Now I realize that I was foolish.
How?
My lords.
Or the court was foolish and granted.
No. I thought, my lords, that this is an open and shut case. I was never in the field. I was not arrested. Who accused made a statement that I have supplied him the brown sugar. So I was arrested from my house at West Bengal and I am in custody. The learned judge, my lords, he charged me with possession of brown sugar. So I thought it's an open and shut case, but I find that it's not progressing. Now, during that period, this period, the trial was at a standstill because the trial judge was not there. Now, my lords, the case has been transferred. An innocent man remains in custody with the trial being stayed because the matter is not being able to be taken up and disposed. So if the interim orders are vacated, at least let evidence be recorded, let me be acquitted. Because it seems this court is not interested in taking up these matters for final disposal.
This has not been assigned to me.
No, I'm not alleging against.
No, not alleging, but this is not assigned to me.
About the Honorable High Court.
2022 matter, that's why,
Yes.
so. That is why probably. So, here only the case diary was called for and the stay was granted.
Yes.
We'll vacate the stay order. or no? We'll vacate the stay order. or? On what ground you have sought for modification?
I say that now since the case has been transferred to a court where the presiding officer is there, let him summon the witnesses, let them be examined.
IA 490 of 2024. This is, which is the IA?
IEM alerts is
1196.
1196.
Yes, sir. IA 1196 of 2024. This application has been filed seeking modification of order dated 23/2023, whereby the proceedings in the court below were stayed. Stop. It is submitted by Sri Devashish Panda, Learned Counsel for the petitioner, that subsequent to the passing of the interim order, the case in question has been transferred to another court, where the presiding judge is available. Under such circumstances, it is therefore the trial can proceed on a regular basis. He further submits that it would not inure to the benefit of the petitioner if the trial is stalled. He therefore prays for modifying the order appropriately. Learned State Counsel has no serious objection to the prayer for modification being allowed. Under such circumstances, the interim order dated 23/2023,
20th of March 2023,
in IA number 3321, not 133, 3321 of 2022, stands vacated. That's all.
the urgent copy of the order.
Urgent certified copy be granted in urgent certified copy be granted. No. Item 25.
We have to. I have a modification order on dated 12/4/24. Well, Lordship allowed the interim order in front of the 12/4/24.
12/4/2024.
Well, Lordship allowed the interim bill in front of the petitioner on that day, with terminated condition bill. In that case, I am for the intervener. I have participated the argument since long, and your Lordship mentioned I have got the informant in cost title para 4 and 7. Though I have filed intervener petition on the 3 intervener, but my name has mentioned cost title para 4 and 7 of the order, that I have filed on the my name has appeared on the informant. Apart from that,
you are not the informant.
I am for the intervener.
Intervener means who?
Siddhar Das.
No, intervener means intervener. What is
I am for the intervener.
Intervener is a party. What? Who is he? Who is he?
Intervener is the one of the complainant before the OW.
So he becomes an informant.
Yes, no, informant, those are but basing on the one information.
I will just simply say informant in another application. Okay?
Yes. Yes. But in this case, what happened was Siddhartha appeared under the Chittaranjan Mahapatra as per the allegation of the which is registered as per the OW. But I am there are 42 informant before the
one of the informants we will say.
Backward.
You will say one of the informants.
Informant, yes.
One of the
misunderstood my claim that though I have filed interim petition Chittaranjan Mahapatra.
Oh, I will do one thing. I will say informant, comma, the name. Name ta dekha lijo. No, if we mention your name, the name of your client,
yes,
then that will suffice.
I am for 3 interveners. Those are the informant before OW. Chittaranjan Mahapatra, Devashish Kaur, Vivekananda.
That we will say.
Yes, apart from that, also let's be protest the interest of the intervener or the some of the informant. Well, let's see, allowed directed in that case refund the amount in front of the informants. But since the UW registered one FIR, yes,
informants will make it informants.
as per the OW order, as per the RERA court order. ତାଙ୍କର ତ ଏସବୁ ଲେଖିଲେ
The application for modification has been filed. Seeking modification of order dated 12/4/2024. Stop. Sri Prafullo Kumar Karo, learned counsel, appearing for the informants, namely
ଚିତ୍ତରଞ୍ଜନ ମହାପାତ୍ର,
Chittaranjan Mahapatra,
ଦେବାଶିଷ କର,
Devashish Karo,
ବିବେକାନନ୍ଦ ଦାସ।
and Vivekananda Das, submits that the order does not specify the names of these informants either in the cause title or in paragraph 4.
4 and 7.
Paragraph 4 and 7. He therefore submits that the names of the informants for whom he had appeared be mentioned in the order sheet in order to bring clarity. For clarity. Stop. Sri Patra, learned counsel, appearing for the OPID, on whom a copy of the modification application has been served, has no serious objection to the prayer for modification being allowed. In such view of the matter, the order dated 12/4/2024 is modified only to the extent of adding the names after the word informant occurring in the cause title, comma, paragraph 4,
7
and 7.
Yeah.
Further, in paragraph 10, the word informant is substituted by the word informants. So,
direct to refund the amount as per the ଲେଖିଛ ଆର କେସ ଦେଇଛନ୍ତି ସେ ହଉଛି କଥା।
it that they shall make sincere attempts to repay the amount due to the informants ହେଇଗଲା। informants କିଏ କିଏ ଆଗରୁ କୁହାଗଲା।
Item number 26.
26.
Your Lordships, on behalf of learned counsel Mr. B.R. Tripathi, I may be permitted to appeal. Lordships, this is the second application of the petitioner for extension of time of interim bail. Previously, he has been granted 2 months of interim bail. His interim period is going to end on 15th May, Your Lordships.
What ground do you want?
The illness of his wife, she was having some gynecological issues. And previously, medical documents has been filed in the previous IA, Your Lordship.
All right, one last chance.
Once granted, once extended.
Extended by 2 months. All right, all right.
14/3/2024.
All right. Be considering the submissions made. And on the the interim bail is extended for a further period of 1 month. Stop. It is made clear that no further extension shall be granted. Yes.
27.
Obliged, Lordship.
Yes, case number has been wrongly typed as 44 of 23. At paragraph 1 of the judgment of Your Lordship.
Paragraph 1.
It should be cyber crime economic offense PS case number 45.
45 to 44 is.
ଆଜ୍ଞା ଏଟା ଇକୋନୋମିକ ଅଫେନ୍ସ ଜାଗାରେ ଇକୋନୋମିକ ଅଫିସ ହେଇଯାଇଛି।
Considering the submissions, prayer for modification is allowed to the extent of substituting the word office by the word offense occurring in paragraph in the second line of the first paragraph and substituting the figure 44 by the figure 45 also occurring in the same.
In the first title of the petition.
What cost it? What?
ସେଥିରେ ହେଇଯାଇଛି economic office PS case number that should be offense.
ତ ଆମେ ତ ଅର୍ଡର କରିଦେଲୁ ଆଉ କଣ ହେଇଗଲା ଆଉ କଣ ଅଫିସ ଟୁ କ୍ୟାରିୟର କଷ୍ଟ ଟାଇଟଲ ହବ ସେଟା କରିଦିଅନ୍ତୁ and also in the cost title. Yes.
28.
I'm a juvenile and admitted to Sudarakro University 23/2022. That
Have you
means,
received a copy of the statement
Yes,
of
yes,
deposition?
yes.
Yes.
and I'm costed 2 years, 3 months, Your Lordship.
Yes.
I filed an application for 12 Your Lordship Juvenile Justice Care and Protection Act before the court that has been rejected for bail, Your Lordship. And after rejection, as per the provision of law, filed the safety. In course of appeal, Your Lordship, a report has been called for regarding social investigation report. And now that has been supplied to me. Vis-a-vis to the deposition, the deposition Lordship in respect of adult co-accused person, they are facing the trial where I am not the party to the proceeding, Your Lordship. So in that social background report, Your Lordship, I found there is no negative impact against me, Your Lordship. Rather, Your Lordship, stated the Lordship, I have no criminal background. My father is also no criminal background. And before I implicated in this case, Your Lordship, I was doing a job in cable networking service.
Yes, yes. Go on.
In
You are,
Lordship.
what is your name?
My name is also Vivek Naik, Your Lordship.
Nilu alias Vivek Naik.
Yes,
Go on. Go on, go on.
The entire the social investigation report, Your Lordship, there is no adverse remarks against me, Your Lordship. And I have no criminal background. This is the first case against me. And so far the report given that how I committed this crime is stated that.
What is your age?
17 plus, Your Lordship.
17 years, 10 months and some days. And on the date of occurrence? Yes. So what is the, let us see that Sarojini Sita's
Sarojini Sita statement that is
Deposition?
that deposition Your Lordship, hardly if Your Lordship taken to consideration where I am the party the proceeding, that is in respect of adult co-accused person, those are facing trial. They are advanced a case of against me, Your Lordship, unlawful assembly. There is no specific overtime against me. It is no doubt is a organized crime, Your Lordship. The organized crime, Your Lordship, every person is required to be specific involvement so far the crime they have been committed. The first offender, Your Lordship, as per section 12(1) of the Juvenile Justice Care and Protection Act, Your Lordship, while considering the application for bail under section 12 of the Juvenile, the court has to locate to so far the social investigation report and the person who is the appropriate person to take care of the child. Now my father is also will file an affidavit. He having no criminal background is a that he will take care of the child.
Let me just go through.
सेक्टर आज्ञा पैराग्राफ 17 18 ता देखिदेले बहुत बड़ डिपोजिशन होची मो स्पेसिफिकली तो पढिथिली.
On that day at about 11 AM, Jhuna Didi, Sharmishta Madam, Raj Bhai, Vivek Bhai, Bhagyadhar and Manas Bhai came to ashram. They took
Manos religion
Bhai
bail, Manos religion bail.
No, Manas Bhai to the guest room. Raj Bhai, Vivek Bhai and Bhagyadhar Bhai told Manas Bhai to remove his shirt, and when Manas Bhai did not open it, you are Vivek.
I am Vivek.
So it is in paragraph 16.
Yeah, one is.
I had been to the house of Sharmishta Madam to do some household work. When I was present in the house of Sharmishta Madam with her sister-in-law, at that time, Jhuna Didi made video call to the sister-in-law Bhaujo of Sharmishta Madam and showed through video call Manas Bhai, Sharmishta Madam, Jhuna Didi, Raj Bhai, Bhagyadhar and Vivek present in the car of Sharmishta Madam.
Yes,
in that car itself, the deceased was kidnapped?
From kidnapping to killing, he was present.
Lordship, so far Sharmishta and Niranjan Sethi, Lordship. Niranjan has been released and well submitted in custody. They have been chalked out all the plan, Lordship, because a jeep was kept by the deceased Manos.
That I know, that I know.
Yes, my lord. Now, here were two sets of investigation agency, Lordship. One is the General Police, another is the CIDC.
Crime branch.
Crime branch, Lordship. Lordship. So far the evidence produced before this court, Lordship, that has been recorded, Lordship, on 6/7/2023. For the charge sheet submitted by the crime branch, Lordship, that is also 6/7/2020. So the deposition taken to consideration, so the general police and so far the taken to consider CBI, that has not been taken to here, Your Lordship. And my respect, sir, I cannot be compared with this person because I am a individual to be juvenile. As per section 12(1), I have to consider it. If Your Lordship social investigation report goes against me, then Your Lordship, I can say that I have no case at all. But the social investigation report has never been whispering anything that yes, I have a bad reputation and my parents having bad reputation.
No, but if there is a prima facie evidence of your participating in the crime, that will override the social investigation report. Isn't it?
That's true, Your Lordship. That's true, Your Lordship.
There is a prima facie evidence, Mr. Jana. And there is what I find from the deposition. Briefly, I have not gone through the entire thing. I have not applied my mind 100% to the other parts of the evidence. Is that you were present in the car? In that car, this person was taken.
Yes.
After he was assaulted, his dead body was carried.
Yes.
He was cremated, or rather, he was. His dead body was buried somewhere. You were present all through.
Let's say everything Your Lordship's content is correct. But the similar circumstances, other co-accused persons,
Let us see.
on bail.
Let us see.
They are Your Lordship.
Let us see. Parameswar Raut has been released on bail.
Parameswar Raut is the
Totally
brother.
different.
He's the brother. He only sent money to
Then Niranjan Sethi. Let us see Niranjan Sethi. Niranjan Sethi ବିଷୟରେ ଇଏ କଣ କହିଛନ୍ତି କିଛି ତ କହିନାହାନ୍ତି।
ନିରଞ୍ଜନ ଆଜ୍ଞା ତାଙ୍କ ସାଙ୍ଗରେ ସେ ରୁମ କୁ ଯାଇଥିଲା ଯୋଉ ରୁମ ରେ ଥିଲା ସେ ବି ପିଟା କରୁଛି।
but he is not coming under similar footing like the present accused person.
ନା ଦେଖନ୍ତୁ ମାନସ ଭାଇ, ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ, ଝୁନା ଦିଦି, ରାଜ ଭାଇ, ଭାଗ୍ୟଧର and ବିବେକ ଏମାନେ
Niranjan was not there at the time of kidnapping.
ଏମାନେ କେହି ବେଲ ପାଇନାହାନ୍ତି ନାଇଁ?
ନାଇଁ ଶର୍ମିଷ୍ଠା, ଝୁନା, ରଞ୍ଜନ, ରାଜ, ଭାଗ୍ୟଧର
ଏମାନେ କେହି ବେଲ ପାଇନାହାନ୍ତି।
They are unable to produce two other depositions, Your Lordship, in which case I am facing trial, Your Lordship. The deposition I filed before, Your Lordship, a glance. That has been filed on 19/3/2024. That copy is also there. That is your Lordship.
Chandra Panda. He has identified.
Saurabh Chandra Panda. That
he has identified Vivek, my lord. NTI.
Correct. Before identification, they have been shown in the TV that admitted in the cross examination. ताको टीवी रे देखैतिले तापर जाई से ताको आइडेंटिफिकेशन कर दे एडमिटेड इन द cross examination
आइडेंटिफिकेशन रे छाडी दियंतु।
That is one is Your Lordship. Only these two persons are examined so far my case is concerned. Your Lordship, a glance. I am in custody 2 and 2 year 3 months, Your Lordship. Only two persons are examined. If Your Lordship impose any stringent condition, Your Lordship, taking into concern section 12(1) is concerned, I'll take care of it. My father is now taking care, given affidavit to that effect, Your Lordship. The case of Your Lordship against me unlawfully assembled. There is no specific allegation that I have been assaulted, Your Lordship. Assault allegation equals to the Sharmishta City
unlawful assembly. There will be a common object thing. 149.
That's true.
So you will be liable under 149.
Your Lordship, a glance upon the assault allegation paragraphs of the deposition part is concerned. Paragraph 18 also. Raj bhai, Vivek bhai and Bhagyadhar bhai told Manas Swai to remove the shirt.
No,
where Manas bhai did not open his shirt. Then Raj bhai torn the shirt and assaulted.
You are Vivek.
I am Vivek. But I have never been assaulted.
How it can be segregated?
ଆପଣ ଯେତେ କହିଲେ ଯେ ସାର୍ ବାହାର କର ସେ ସାର୍ ବାହାର କଲାନି ଯେତେବେଳେ ରାଜ ଭାଇ
ରାଜ ଖୋଲିକି ପାଡିଲା
ତା ସାର୍ଟକୁ ଚୋରି କରିଦେଲେ
ସ୍ପେସିଫିକ
ହଁ
I specialize you to remove
ଚଟକଟ ମାରିଲେ
share and when
ସେ ଜାଗାରେ ଠିଆ ହେଇଥିଲେ
Manas bhai did not open his shirt.
Mr. Jana, no, Mr. Jana, I've read it. ତା ଆପଣ ସେ ପାଖେ ଛିଡା ହେଇଥିଲେ
but ସେଇଠି ଥିଲେ ଆଜ୍ଞା ସେ there the stipulation so far this is confirmed. But second, one thing, Your Lordship, how far this statement, Your Lordship, helped to us because, Your Lordship, the special crime batch so far in cause investigation, they 161 statement so far Sharmishta is concerned, there has never been whispered a single word against me. Rather, the general police statement said that I was there, Your Lordship. So if the Sharmishta examined so far my case is concerned, definitely I make confrontation so far the two part of the investigation caused by two independent agencies, Your Lordship. One is CBI and another is general police. That has not been against me, Your Lordship. So now this deposition has been recorded so far adult witnesses are concerned, adult case, Your Lordship. There so far the CBI investigation part is concerned.
It's not a question of utilizing this evidence against you. It cannot be utilized.
Yes,
in the trial, say Sarojini Setia has to be examined again.
Yes, ma'am.
That evidence will, but we are looking at the the nature of your involvement.
That is true, it's a crime is there, your lordship, and so far the in statement of the concern that my presence was there there is no doubt. But for this count, your lordship, section 12(1) can be defrosted, your lordship. If your lordship, I am custody 2 and 3 months, your lordship, I may be allow your lordship in any stringent condition, my father will file affidavit to that, already filed the affidavit.
No. You are 17 years, 10 months at the time of occurrence.
Yes.
Now you are more than nearly 20 years, 19 years and all.
Shall I pray the keep it?
Keep it
To after vacation. In the meanwhile, so far my case is concerned, so Mr. will definitely examine.
সেটা তাহলে ভালো মতো।
After vacation also.
In that case, in juvenile case. Sri General and Counsel for the petition submits that since trial is in progress, he would produce the depositions of some more witnesses examined in the meantime. List this matter. What a vacation for a date call?
9th July.
9th July.
Item 29.
May I please, your lordship? My lord, the petitioners have filed this petition, my lord, praying for questioning the criminal proceeding, my lord. And
Wait. Why it has come? Office
last occasion.
No, I had office to inform whether the order dated 6/3/2003 passed by this court in criminal miscase was coming. Why did I ask this? 12/4. 6/3/2023.
Previous order ota thila. Previous order.
Office notes indicate, office note indicates, states that the order dated 6/3/2023 passed by this court in CRLMC number 1041 of 2023 was communicated to the learned SDGM Kotak Sadar through the order communication portal of this court on 16/4/2024. No, that the order dated so and so was communicated to the court of learned SDGM, to the communicated to learned SDGM Sadar Kotak through DCP wide memo number, order communication portal 14/3/2023. এটা কিন্তু দেখুছি order communication portal টা যারা দেখতেল সে লেখন্তু order communication portal shows কোন লেখা হচ্ছে the date is something else. কোড লেখা আছে 14/3 হ্যাঁ date of issue. Okay, 14/3/2023 লেখুন 14/3/2000. Why did this court want to know about this? Why have you filed this case?
Why the petitioners did not appear, my lord? And this honorable court has pleased to direct the learned court below to expedite the trial, to conclude the trial within 4 months. And that order is there, my lord. That has been my lord, hearing this case, my lord, on the last occasion.
No. Completed. What we were saying completed. What happened? Why have you filed this? What is your prayer in this?
To
set aside for the criminal proceedings was started against the petition. You want to quashing?
Yes. In view of compromise between the parties.
The marriage had already been settled, my lord, in between the petition number 6 and my lord, kindly see annexure, my lord, annexure 6, my lord, page 53. That is marriage certificate. Marriage has been settled and thereafter annexure 7, my lord.
This is a 376.
It has been placed with a male child, my lord.
376, I don't.
My lord, they are leading a happy conjugal life, my lord.
39
For the
weekly
info-
list.
Yes, and I'm for the informant. Somehow missed the list. Maybe taken up along with 93
कौन
items.
है इच item 39 टे कौन है इची?
Charge sheet submitted 302. Your lordship may that husband matter is 93. That may be taken up along with that.
नहीं, what order was passed?
Similar order disposal.
Disposal इची. कौन है?
Mother-in-law, your lordship allow earlier. At that time, charge sheet not filed, your lordship allowed the application. So far as the petitioner is concerned, 302 charge sheet submitted. I have missed the list.
इरे
That's why my
को
lord-
मैटर है?
39.
39 टे खुलचो. तो
That
39 टे कोटो.
APLAPL 3176 of 24.
Uma Mani Ponda.
Yes.
This is the mother-in-law.
Uma Mani, your lordship granted bail.
You
Rajkishore Panda, 39.
So you want to object it?
Yes, sir.
I have passed a similar order. I'll record your objection. I'll record your objection.
Yes. If your lordship-
Vehemently objected. Objected with this.
302 रे charge sheet ହେଇଛି କିନ୍ତୁ. Yes, yes. Yes. My name may be indicated.
ये तो खाली बस order लिखो श्री ज्योतिर्मय साहु Learned Counsel appearing for the informant vehemently opposes the prayer for bail by submitting that there is prima facie evidence to show the complicity of the petitioner in the alleged offence.
Yes.
I beg your pardon to mention before your lordships. Item 26 of the supplementary list. Your lordships, copy of order may kindly be supplied during course of the day.
Item 26.
Your lordships.
Item 26 रे कर दो copy in course of the day. It is item
deeply obliged.
Weekly list item number 41.
May I please, your lordship?
Sorry. Item 41.
May I please, your lordship? Alleged offences are section 9 and 31 of the Wildlife Protection Act. My lord, as for the prosecution story due to electrification.
One Sagar Majo, that elephant.
My lord. And your lordship was,
Segudia is the principal accused.
one of the co-accused, your lordship was pleased to grant them bail.
He was implicated on the statement of the
My lord,
accused.
confession.
Same order.
Obliged.
14927 of 23. That's
Yes, sir.
Obliged.
item number 42.
Optimal offences is 20A Roman I and
CORAM नहीं
27 of the Forest Act and 20 of the Arms Act. My lord's already granted
Bail to one Surendra Sahu.
My lord.
Does he stand on the same footing?
On my lord ticket. Consolidated cost ଟା ଟିକେ NDPS ଟା miss ଲେଖା ହେଇନି ସେଟା ଟିକେ.
Alright. Say first is लिखो Learned Counsel for the petition is permitted to correct the cost title in the court. Court तो हबो नहीं is permitted to correct the cost title in the office.
ଏଟା ଟିକେ ରଖି.
ସେ କଣ ଏଠି ରଖି ହବନି ଆଜ୍ଞା 2024 matter ରଖି ହଉନି.
Item 43.
43.
May I please, your worship? My lord, the offences are under section 341, 294, 323, 325, 307, 506.
One Sheikh Saifuddin has been granted bail.
My lord.
Sheikh Sunil.
Sheikh Sunil.
Sheikh Sunil alias Sheikh Saifuddin.
My lord.
Same order.
Item 44.
My same lord.
May I please?
Offense under 307 matter. In this case, matter due to civil dispute. Other co-accused person already released one. The present petitioner earlier appealed this court matter. Lawsuit direct to present petitioner factor asa करना. And in the meantime, injured already discharged and matter.
What is your name?
Boston.
You were granted bail first or second or?
Mine.
So? तो खाली पैरिटी हो कौन?
Parity.
फिर C3 को मॉडिफिकेशन फाइल करना C3 फाइल कर दो ताको पैरिटी कर देबे
एटा उडर लिबर्टी में
सेटा फाइल करके एटा वीडियो करो
हम काली
फाइल कर दो पास ओवर
Item 47.
My lordship. The offence has been committed to 94 to 323-34.
Only Kanta Barada has been granted bail. There is a civil suit. Same order.
Right. Obliged.
Item 48.
Pass over.
Item 49.
May I please, your lordship? Well, in this case, my lord, the petition number 1
is the father of Sitakant Digal. The petition number is the mother. Petition number is the sister, madam. Of the principal accused, as per prosecution case, who is alleged to have kidnapped the daughter of the informant. My lord, here in this case, my lord, prior to submission of charge sheet, the petitioners made an application before this honorable court praying for anticipatory bail. This honorable court was free
First
to
or
grant
second?
first or second order. Thereafter, my lord, after my lord submission of charge sheet, my lord, and cognizance was taken, my lord, they have been summoned, my lord, for appearance. Charge sheet has been submitted under section, my lord. Kindly see.
You did not abide by this order.
My lord.
You did not abide by this order.
In compliance to the order passed by my lordship, the petitioners.
They were surrendered or released on bail.
So, but after submission of charge sheet, my lord, they have been summoned for appearance, my lord.
So they are
on.
Is any higher, has any higher office?
Again, my lord.
Higher
366, my lord.
366.
Again. So, Bappa Ma Bhauni.
Where have you said that?
46, my lord. 46, my lord. 46.
No, you were granted bail.
By the learned SDGM Fulbani.
What is the offences for which you were granted bail? Only
363, my lord.
Further 376(3) has been added.
Not against these petitioners, my lord.
Where is that?
Against Sitakanta.
Charge sheet.
Charge sheet kind?
Page 40, my lord. Page 40 last, my lord. Page 41 last.
Page 41.
363, 366, my lord.
Three were made out against accused person, namely Sitakanta Digal.
The principal accused.
Achha. Under 363, 366, 109 against accused person Surjakanta Digal, Sarojini Behra,
and
Subhasmita Digal.
And Subhasin Digal. So, Bappa.
What's going on?
366.
Oh, 366. So, what is that? My recent judgment, what have you said? What is my recent judgment?
Susil Agrawal versus State of
I have passed a recently judgment.
For the second bail application, which mentioned.
No, not second application. If an higher offence is added, what is required to do? I have said that he doesn't have to surrender. It is for the prosecution to seek his arrest.
Yes.
He may move the court.
Either he may move before this court or prosecution from side or the prosecution has made an application.
We will grant him anticipatory. We will grant him bail. So they are already on regular bail now.
Again.
This is
anticipatory bail will not lie. You are on regular bail now.
Yes, my lord. After surrendering, I have.
যদি আপনি regular bail রে অଛନ୍ତି বর্তমান, how can you pray for anticipatory bail?
Well, they are
an application before the court.
Well, they are apprehending. That in the event of their appearance, they may be remanded, my lord.
Had you not been arrested in connection with this case at all, then anticipatory bail application will lag. But once having availed an order of first hour and second hour, what it is? It is custody bail. You surrender, went to custody, and then after you were released on bail. So it becomes a custody bail.
When the case was reached under
so Pradeep Ram. Here this will be Pradeep Ram will apply.
They have kindly see the consistent statement of the victim girl. That I do understand, my lord. So, but my submission.
So, unless the application is maintainable, can the court pass any order? I am on maintainability of Mr. Behra. Please consider I am on maintainability. Please examine my decision, my judgment. I am calling it tomorrow. Correct.
In case of Susil Kumar Agrawal versus State of Uttar Pradesh, my lord.
Yes, Sushila Agarwal.
Sushila Agarwal is different footing.
Sushila Agarwal totally different. Where anticipatory bail has been granted, it will continue. Have you been granted anticipatory bail?
No, first or second order.
That is anticipatory bail.
No, my lord.
That is custody bail. So you have already you are on bail under section 439, not 438.
Yes, ma'am.
I'm still, if you want, you can go through that judgment. I have discussed in detail. I think Mr. Saurabh Chandra Mahapatra was arguing that matter. Yes. Higher offense. No, Mr. Devashish Pandit.
And it's
well, here in this case, my lord, this honorable court, my lord, may direct the learned court below in the event of the appearance of the petitioners, my lord, they may be released on bail, my lord.
How can this court pass an order on an anticipatory bail application which is not maintainable?
Because they are under apprehension, my lord. In the event they appear before this trial court, my lord,
Better he move an application before there and move for bail.
they are apprehending that in the event of their appearance, they may be remanded.
No. I'm giving you opportunity, but you are not taking it. I'm passing that order. I'm rejecting it. I'm rejecting your appeal.
My lord, it may be urgent to.
That is what I'm saying.
Yes.
Go through the judgment, please examine the law, find out whether your application is maintainable or not. You are on bail now. Once you are in bail, the 438 application will not lie. 439, yes, because of Pradeep Ram. Pradeep Ram will come into picture.
Yes.
Directly Pradeep Ram will come into picture. So please examine the law, then we will see. Yes. I'm passing it over.
It may be urgent to someone.
Then it will urgent means it will come only after vacation. If I adjourn it, it will come after vacation. Now, coming week, so this in matter.
Day after tomorrow.
Day after tomorrow, Kali. Day after tomorrow, Kali. Yes. Pass over. Mr. Behra, please go through those judgments.
Okay.
Item 50.
May I please just. Here, 379 of IPC is there, against an unknown person regarding theft of a bullet, in the meantime, you will also be granted bail.
Chiranjeevi Jana. Same order? Same order, Mr.
Yes, ma'am.
Yes, same order.
One thing, I am filing the memo, in the meantime, charges from 379 34 of IPC. Only, you also indicated in the order, 379 34 as may added.
379 34 add kar dega.
Item 51.
274, 275, 34 IPC and 21 P. The NDPS at your lordship. Present person similar putting with the
Yes, corp.
Same order.
Item 52.
302 and other offences. That matter, your lordship has granted 5 of the accused persons to the bail. 27 persons named, and out of the 5 persons, your lordship has granted bail.
Call for the city. Appropriate case diary. Appropriate case diary be obtained. Release this matter. In the week commencing? 24th. 24th June.
No course. Others are your lordship has granted.
Others one जो वाले involved not सुविधा खुदी है तो
हाँ नहीं ये भी
the mother of that auto rickshaw driver तो
yes ये ना खाली अच्छी से 3 जन तो भीतर अचंती ये murder court
all right no course of action till the next date.
53.
379 34 of IPC. That is 12 of Orissa Mines Act, my lord. The present petitioner is the owner of the vehicle, my lord, not named.
By me, 379 34 12 IPC. Earlier you had withdrawn the bail application?
Not named for which it was withdrawn.
Now you are named?
No, confession of co-accused, my lord. One of the driver was
Where is that statement?
He is the owner of the vehicle.
owner of the vehicle.
Yes. What was it carrying?
But his
Manganese ore and same has been recovered, man.
What was he carrying?
Manganese ore.
Manganese ore.
Cement bags are containing manganese ore and some cash.
The petitioner is apprehending arrest in connection with such case. Stop. It is alleged that he being the owner of a truck had allowed the vehicle for the purpose of illegal transportation of manganese ore. Stop. He was not named in the affair, but has been implicated, as submitted by learned counsel for the petitioner on the statement of the co-accused. Surrender, release on bail. Okay.
It was 54.
May I please, my lords. Lords, the lordship have earlier granted similarly footed co-accused persons bail, my lords. That is at Annexure 2 series, my lords. Page 28.
Susuma Kaur.
My lords. And another one.
No.
He is not coming under similar footing.
Up to date case diary be obtained. Release this matter in the week commencing 24th June. No course of action till then.
Petition number 1 and 2, they have filed earlier anticipatory bail 762 and 13620. What order has been passed in, again, here they have filed.
List this matter on in the week commencing 24th June along with ABL number
ABL is 762 of 24
762 of 2024 and
13620 of 23.
13620 of 2023. Yes.
That has been withdrawn.
देखिए आसो
Item 55, adjourn bail application.
कौन लेटर कौन আসছে letter of the Leonard SDG Margod as forwarded by the Leonard Sessions Judge reveals that the petitioner, after being released on interim bail, has not surrendered to custody, for which warrant has been issued for her production. Since the petitioner has violated the order passed by this court, the bail application stands rejected. The court below is directed to ensure early execution of the NBW issued. Yes.
Item 56,
This order will be communicated to the court below forthwith. Item 56. Oh,
item 57.
yes, Dr. Paul.
My lord, here the petitioner is in custody since 24/2022. More than 2 years in custody, my lord.
23
22, my lord.
22.
24/2022.
302 matter.
Yes, ma'am. My lord, here is a case, my lord. Initially 307 was registered.
What is your name?
My lord, Ganesh Baral,
Ganesh Baral.
alias Pitavas.
The husband Akshay Kumar Pradhan went to Krishna Vihan or buying vegetable at that time. Vegetable shop to Ganesh and her husband. They argument with each other with vegetable rate. Suddenly Ganesh assaulted her husband by means of hidden plank.
My lord, here is a case. There is no intention is there, my lord.
Who is the main witness here?
Here, my lord, I have supplied one Govinda Chandra Behra, the eyewitness, one of the eyewitness.
Thank you.
Another
Has he been examined?
Akshay Kumar Sahu.
Sanjay Kumar Pradhan, Subrot Sahu and Akshay Pradhan.
Have they been examined?
No, madam.
No, even accepting the prosecution case, what does it reveal? He had gone to buy vegetables. This person is a vegetable vendor. They had a quarrel over rate.
There is cerebral
cerebral hemorrhage
and that wooden plant was also, it was seized. It may be 304B, my lord. No,
304B hapani. Ha 304B.
304B.
304B kemne 304
part 1
part 2 habo. 304 part 2 habo.
Ha 304 part 2.
Knowledge without intention.
It's 304 part 2. That I said 304B, my lord. 304 part 2.
All right. The petitioner is in custody since
24/2022.
24/2022 in connection with such and such case.
Yes, sir.
It is alleged that the petitioner is a vegetable seller having a shop in the market stop. The deceased had come to his shop to buy vegetables. Stop. There was an argument between them over price of the vegetables, which led to a quarrel, in course of which the petitioner is said to have assaulted the deceased by means of a wooden plank. Yeah, though?
Yes.
Huh? Now,
Yes.
I was got nothing. Sure. Then counsel for the petitioner submits that the prosecution case, even if accepted on face value, does not reveal a case under section 302 of IPC in the absence of any evidence regarding premeditation or intention to kill, intention on the part of the deceased, on the part of the petitioner to kill the deceased. Then at State Counsel, while opposing the prayer for bail, submits that there are eyewitnesses to the occurrence, which witnesses to the occurrence who have stated, who have clearly stated about the role played by the petitioner. Para. Considering the submissions and the nature of the and the circumstances in which the petitioner is said to have assaulted the deceased, it cannot prima facie be said that he was actuated with the intention of killing him. Stop. In such view of the matter, as also having regard to the period of detention of the petitioner in custody, I am inclined to allow the prayer for bail. Let the petitioner be released, each day appearance without representation.
And my lord, he shall not come contact with the eyewitness.
Further, he shall not try to influence or terrorize the prosecution witnesses in any manner whatsoever.
Item 58.
Report was confirmed from the jail authority regarding the health costs.
Yes. Yeah, so he was suffering. He was suffering. So we'll grant him interim bail.
Interim bail.
Kete kg?
1 kg, 109 gram.
And brown sugar?
Yes, sir. ମୁଁ ଯାଇଥିଲି ଥରେ ଆସିକି ପୁଣି ସଣ୍ଡର କରି ଟ୍ରିଟମେଣ୍ଟ ହେଇକି ଆସିକି ପୁଣି ସଣ୍ଡର କରି ଯାଇଛି ମୁଁ କଣ୍ଡକ୍ଟ ଆଜ୍ଞା ଦେଖନ୍ତୁ ଥରେ ଇଣ୍ଟରଭ୍ୟୁ ଯାଇକି
ଆପଣଙ୍କ କଣ୍ଡକ୍ଟ ହିଁ ଦେଖୁଛି 1 kg brown sugar and you are asking the court to see the conduct.
In fact, this is
All right. As directed, then State Council has obtained written instructions from the medical officer attached to the district jail Nayagarh regarding the health condition of the petitioner. It is stated that he has been undergoing treatment for several neurological ailments for a long time. So presently also, he is complaining of pain, though he is said to be clinically stable. Considering the report so submitted, I am inclined to take a lenient view. Shall we keep it pending?
Madam.
I will keep it pending. Let the petitioner be released on interim bail for a period of 2 months.
lengthy process treatment.
No. I was myself suffering from spondylosis, so I know. 2 months. Even now also, I changed this chair only for that. So we did not get any interim bail from our. Interim bail, let the petitioner be released on interim bail for a period of 2 months. On such terms and conditions, as the court below may deem fit and proper to impose.
Obligers.
Will this matter? Dimas forward date karo.
In the week commencing 22nd July.
Dimas is it? Will this matter in the week commencing 27th? 22nd July. All right. Item
59.
59 के नाथ. Shut up. 60.
Item 60.
My lord.
My lord, this is
62.
present petition of the custody since my lord 2/12/2020.
Item 59 Miller. Last taken direct to State Council Miller.
Mr. Mishra is not there, so let us wait for second. Raji Nole kali habo.
Again. What time no to share tangar se
See, nahat boli muno otherwise I would have granted kali. Kali dekho. If you find him, Mr. Patra, tell him.
No, kali.
My lord, the present petition custody since 2/12/2022. My lord.
No. On the last occasion, you said that some witnesses have been examined and you got time to produce the depositions.
2 witness examined, my lord.
This is a 302 matter.
My lord.
Key examination.
Informant and his doctor. I'm from the postmortem.
Yeah, see the point. କହିଛନ୍ତି ଆଉ କଣ? Directly
Also, by push and pull, there is a, and as per the postmortem reports, it clearly indicates, my lord, no external body injury of any kind detected. No ligature mark, no, everything it has been.
You go through the paragraph 12, we'll take it up after lunch. Go through this deposition, particularly paragraph 12, compare it with the postmortem report. Because he has a specific, the witness has referred to specific assault on specific areas. Whether the postmortem report shows corresponding injuries in those areas or not.
PM report might that instantaneous psychological death, which may cause to minor trauma or relatively simple and harmless peripheral stimulation.
So this could be that 304 part 2.
Part 2. But my lord, his conduct, he wants to ask that present petitioner assaulted his father. This is the uncle. He came to say, for that reason, he assaulted his uncle.
Only there is
that is his conduct. And the eyewitness, my lord, another eyewitness there.
No, even accepting whatever you say is correct. What will it be a case under 302?
Not 302. But
so this will be again knowledge without intention.
My lord.
Knowledge without intention. Paragraph 2 ta padho. We'll continue. Yes, Mr. Mishra. Mr. Patra was seeking time.
My lord.
After OPID counsel.
Yes, my lord. So
he was asking for some time. Should I adjourn it?
With regards to the affidavit filed by me, my lord.
Let it, you call him. I'll take it up after recess and then I will adjourn.
Obliged. Obliged.
Yes, item 60.
Item 60.
Yes.
My lord, I have checked up that the injury caused, there is no external injury. Or the injury is corroborated to the assault part, my lord. Because my lord, kindly say, my lord, that the death is, my lord, due to peripheral stimulation. That is the nerve problem, due to nerve problem. And because of that vagal inhibition, that the condition that can lead to sudden death. Because my lord, on which part he has assaulted,
yes,
that is
why I had given it to you.
My lord.
All right.
That part he has assaulted. So with the
But it will not be murder. It will not be murder.
No, this is a matter coming under 304 part 2. This is 304 part 1. But everybody knows that if we will assault on that part, that basically that person will my lord die. That is the is the common knowledge of all, my lord. If we will assault on that part, my lord, he will pass that.
But no sign in the postmortem report does not say that the postmortem, my lord.
ଆପଣ ଶୁଣିଲେନି ସେ କଣ କହିଲେ? ଯାଉ ଦେଖିବା ଭ୍ୟାକେସନ ପରେ ଆସୁ let's take matter after vacation.
My lord.
You make a mention, I'll list it. ଯାଉ ସେ ଜୁଲାଇ ମାସ ଯାଉ ତ ତାଙ୍କେ.
My lord. Published.
I don't know 61. 61. Pass over.
Item 62. Oh, ma'am, withdraw this application.
Withdraw. All right. Permitted to withdraw.
Permit to after charge sheet filing after.
With liberty to move to renew his prayer after submission of charge sheet.
No, 63.
63, may I'm appearing to PC, my lord.
Yes.
My lord, this is a case under section 307. And I have uploaded the deposition copies of PW1 and PW2, my lord.
No, I must have uploaded kain. Who to upload करछंती कोन करछंती किछि नाही.
Memo करी file करथली sir.
ने देखिलो काली के आसी काली काढलो.
Memo and I have also served a copy to the.
You have received any copy? No, no.
I have not received.
They have not received any copy. Kaliki dekhuntu, Kaliki dekhuntu. We'll pass it over, let him find out. Well, you have uploaded it in the High Court website, or where do you do it?
In the official website, in the e-filing.
Acha, find out. So the e-filing, whatever the website is, he claims to have, uploaded it. You find out?
Deposition.
Achi. Deposition copies and also giving copies to for you should in order to give it to the Advocate General, you have to upload it in their website.
I have made a copy to. I have uploaded the certified copy of.
So then mail it to them. Mail it to them.
Already mailed.
Mail it to them with attention, kind attention, making kind attention of Mr. S.K. Mishra.
My lord, I will do that.
Additional Standing Counsel. So that it will reach him.
My lord, I will do that.
Yes, item 64.
64.
May I please, your lordship? In my favor, my lord, 10,666,
The name of Sri Nityananda Mahapatra be deleted from the cause list as directed by order dated 9/4/2024. Yes.
10,666, 2023 in my favor, Vinam.
I'm sorry, I couldn't follow you. What did you say? I couldn't follow you.
जोटा BLAPL दीटा अछि मोर मो फेवर रे भिनामा अछि 10,666
Cool. Kichh asudha.
May I please?
I was just asking them to delete the name of Nityananda Mahapatra.
May I please, your lordship? Petitioner is in custody, my lord, 1/3/23.
1/3/23.
Specific mention in FIR, my lord. Contraband ganja seized from the house of Sanjay Kumar.
Sanjay Kumar.
And he dealing with ganja business and stored huge quantity of ganja inside his house, my lord.
You have the case diary?
Yes, my lord.
What does it say?
My lord, the
house of Sanjay Kumar.
Sanjay Kumar. This petitioner is the son of the Sanjay Kumar mother, who is the father of this petitioner.
What is his role?
From the house of the both this Sanjay Kumar, my lord, and the RI report and the spot map and
Sanjay Kumar has been taken to custody.
Yes, ma'am.
So what is his role? His son?
Both are found to be present at the spot, my lord.
Present at the spot?
Yes, my lord. Apprehended from the spot.
And Kapila Kumar?
Kapila Kumar. He is the son of Sanjay Kumar.
Yes, yes.
Petitioner remains aloof from his father, my lord, and residing in separate house only. Everything.
जाओ किस दिन जाओ देखिए इंटरिम बेल फेल दवा बस हो गलानी
More than 1 year.
all right. What is the status of trial?
Charge sheet submitted, my lord, trial has not come.
All right. The petitioner is in custody since
1/3/23.
1/3/2023 in connection with such and such case. The prosecution case is that huge quantity of contraband ganja, that is
340 kg.
340 kgs was recovered from the house of one Sanjay Kumar. The petitioner is the son of said Sanjay Kumar. Stop. Both were apprehended from the spot. Learned counsel for the petitioner submits that the petitioner has been residing separately from his father. Stop. She further submits that despite submission of charge sheet, trial has not commenced, though the petitioner has remained in custody for 1 year. Stop. She therefore prays that the petitioner may be released at least on interim bail for some period in order to look after his family properties. Stop. Learned State Council has opposed the prayer for bail by submitting that there is prima facie evidence to show the presence of the petitioner at the spot. Considering the submissions and the materials on record, I am not inclined to grant regular bail to the petitioner. However, considering the fact that the petitioner has been in custody for more than a year and trial has not commenced, I'm inclined to take a lenient view. So, the bail application is therefore disposed of, directing the court below to release the petitioner on interim bail for a period of 3 months. Each day appearance without seeking representation. What about the other matter, madam? That is not yours.
Instruction has come. He wants to engage Nityanand Mahapatra as his counsel.
Nityanand Mahapatra has already been engaged. Should I pass over?
My lordship directed to take instruction from the jail authorities to whom this petitioner want to engage.
Okay.
So he wants to engage Nityananda Mahapatra.
All right.
In that case.
Learned State Council has obtained instructions from the jail authorities that the petitioner wants to engage Sri Nityananda Mahapatra advocate to represent him in the case. Yeah. Since Sri Mahapatra is not present, when the matter is called out, let's this matter next week.
Next week, ma'am.
The दिन कोर्ट से जाओ वो.
Item 65.
May I please, your lordship? Under last question, your lordship is directed to government. It's like a verified by my lord. The notice was issued or not, my lord?
Yes, notice served, my lord. 27/10/23.
Notice on the informant / victim has been served on 27/10/23. 27/10/2023, but there is no appearance. The bail application is therefore taken up for hearing. Yes. Statement and everything.
Yes, ma'am.
He along with his medical examination.
Yes, it is there, my lord.
I've written the page number, your lordship, in the front page of the page.
Third page of the
Brief man.
Could be consensual. Isn't medical examination report has ruled out forcible act. What she says seems to suggest forcible, which is not reflected in the petitioner is in custody. Say,
My lord, 2/5/2023, my lord.
2/5/2023 in connection with such and such case. It is alleged that the petitioner took the victim girl on his motorcycle on the pretext of dropping her at home after both of them had gone to attend a funeral ceremony in another village. Stop. On the way, the victim stopped the motorcycle and took the victim inside a jungle and forcibly committed rape on her. In her statement recorded under section 164 of CRPC, the victim has vividly described the occurrence, which prima facie indicates that she was forcibly ravished. Stop. However, the medical examination report is otherwise, inasmuch as the doctor, after examining the victim, found nothing suggestive of any forceful sexual intercourse, though she opined that normal sexual intercourse cannot be ruled out. This, prima facie raises a doubt as regards the veracity of the prosecution case as laid, taking into consideration all the above facts, as also the period of detention of the petitioner in custody. I'm inclined to allow the prayer for bail. Each day appearance without without representation.
Item 66,
Obliged, madam.
Pass over.
item 67,
Pass over.
item note 68,
Yes, pass over.
item 69,
Item 69 kindly pass.
Pass over.
And tomorrow, madam.
Pass over. All right, pass over. It will be called out tomorrow.
item 70,
My lordship,
Yes.
the petitioner in custody since 6th August 2022.
Notice has been issued.
yes, madam.
Notice has been served.
2024.
Yes.
30/4/2024.
Learned State Council submits that notice on the informant/victim has been served on 30/4/2023. Stop. There is, however, no appearance from the side of the informant, for which the bail application is taken up for hearing. Yes.
My lordship, the petitioner is arrested for the offence under section 450, 376(2)(1), 376(3) IPC, arrayed with section 6 of the POCSO Act.
Good.
My lordship,
तीन चार जो ଦେଇଛି ତିନି ମାସ ପାଇଁ
3 months.
କାହିଁକି ଆସିଲା? ହଁ 3-4 ଆସିଛି.
3/4/24.
Yes. Wrongly listed.
Yes.
This matter appears to have been wrongly listed. It is 6th May जो कोई 6th July वाला था सिर्फ है ना? ये कर दो सर लेखन तू. Please this matter. 3-4 माने ये अगस्त मास है ना कौन? Please this matter after 3 months. Yes.
Item 72,
May I please, sir? My lord, here the petition 3/7/2023, my lord. And it's a case under section 376D along with other.
376D रे तो नोटिस सरकार ने.
Here is a case, my lord, while the
Of law. Under which provision of law? Is there any provision of law which permits you to make such a statement?
No.
And for the court to take cognizance of?
My lord's kind consideration on that.
No, kind consideration କଣ ଦୟା ଏଠି ପଞ୍ଚାୟତ ପଞ୍ଚାୟତ କୋର୍ଟରେ ବସିଛି କଙ୍ଗାରୁ କୋର୍ଟ ନା କଣ? ଆଜ୍ଞା I am as much bound by law as you are. So can this case be compounded? Can this case be compromised? I am asking you.
Yes, but as the informant is, my lord, preparing for higher studies, my lord. See,
Let her prepare.
not willing to.
We wish all the best to her.
My lord, they are co-villages and the.
What does the FIR do? It sets the criminal law into motion.
Yes, lord.
And the criminal law, which has already been set into motion, cannot simply be just stopped by saying that I'm no longer interested. In some cases, it can be done. In these cases, it cannot be done. I will consider this application on its own merit. Appropriate case diary be obtained. Let this matter.
Sir,
That is in
commencing 1st July. Sir.
the week commencing 1st July. What, Dr. Paul?
Affidavit, my lord.
किच्छि बिल्कुल दियंतु नहीं किच्छि दियंतु affidavit देबे जदि I will haul you up for perjury for filing a false FIR. I will direct the prosecution to take action against you.
Apologies.
This informant.
Apologies, my lord. I would.
Don't entertain such clients.
My lord.
Yes.
73.
73.
My lordship, I have made a memo to withdraw this petition.
You want to withdraw? All right, permitted to withdraw.
74.
I praise the Lord.
Yes.
My lord, petition has been languishing in the jail custody from 18/3/2023, more than 1 year, my lord.
Yes.
Yeah, my lord, allegation is that 3 persons were, my lord, traveling in a, my lord, car, my lord, by seeing the police person, 2 fled away, and petitioner was moving as a passenger. That's apprehended, my lord. More than 1 year in custody, my lord.
What is the quantity?
1 quintal, 5 kg, 600 gram.
105 kgs.
ବର୍ଷେ ପରେ ରହିଲା ବର୍ଷେ
Yes, what is that?
Apprehended from the spot, my lord.
And the petitioner is in custody since
18/3/2023.
18/3/2023 in connection with such and such case. The prosecution case is that 3 persons, including the petitioner,
traveling in a big car,
moving in a car.
Yes, my car.
Were traveling in a car, which was stopped by police. On search, contraband, ganja, weighing 10 kete kg?
2 bags from dicky and
105 kg.
105 kgs was recovered. Stop. And the petitioners and the culprits were taken to custody. Stop. Then counsel for the petitioner submits that despite being in custody for more than a year, trial?
Trial that 3 4 witnesses out of 18 witnesses.
That only 4 out of 18 witnesses have been examined. Right. Counsel for the petitioner submits that. He therefore
not support.
Yes,
Seizure witness.
He further submits that considering the long incarceration, the petitioner and long incarceration and there being no likelihood of the trial being concluded in the near future, the petitioner should at least be released on interim bail in order to attend to the necessities of his family members. Stop. Then State Council has opposed the prayer for bail by submitting that there is a proof, prima facie evidence of the involvement of the petitioner in the alleged occurrence. Considering the submissions as above and the materials on record, I am not inclined to allow the prayer for regular bail. However, considering the period of detention of the petitioner in custody and the slow progress of trial, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 1 month. You can ask why 3 months for the other bail? Why 1 month? Why? Is the court discriminating? No. In that case, trial had not commenced at all. In your case, trial has commenced and 4 witnesses have been.
Yeah, out of my 19, we must.
বুঝিয়ে দিলি পরে?
6 weeks.
No, 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 no.
6
No, no, বুঝিয়ে দিলি পরে?
6 weeks করতে।
যদি বুঝিয়েলা পরে যদি ଆପଣ বুঝি ପାରିବେ না
6 weeks
ବହୁତ ପାଇଲେନି ବହୁତ ପାଇଲେ। Yes, item 75.
75 ରେ trial ହେଇନି 12/4/2023 ରୁ ଅଛି ବର୍ଷେ ପାରେ। And here they are in the jungle. Ganja was seized from the jungle where 3 persons were stitching the ganja matter, and 2 persons fled away. In the petition of from the ganja, that
yes,
jungle. That is from the jungle.
No, my lord, apprehended from the spot, my lord.
Jungle.
No, he says that he was apprehended. 2 persons fled away to.
Yes, ma'am. A fair story. I have asked. 2 persons from the spot and.
My lord, dear,
My lord, we 2
I
persons.
signal our raiding party to stop the suspected car, and all our raiding party members came over to the road and stopped the car bearing registration number such and such, but the driver of the said car tried to turn back the car, and as he failed to turn back the car, the driver and another person who was sitting on the front seat able to fled away suddenly from the spot to the nearest jungle. So they chased and apprehended, my lord. They were FIR.
आपको किस तरह धरती दी? 1, 2, 2, 3, 4.
Item, yes, my lord, 122 74.
No, 1, 2, 2, 3, 4.
3, 4. এটা জঙ্গল কটেজ রে ইয়ে করଥିଲି।
মানে item 74 তো মানিয়াডিকাল
না মানিয়াডিকাল তো কইলে। হ্যাঁ মানিয়া
ସରିଗଲାଣି।
সেটা ସରିଲା। ସେଇଟା ଯୋଉ ଭିତରେ ଥିଲା ଯୋଉ ଗାଡିରେ ଯାଉଥିଲା।
It was one Maniadigal granted 1 month, my lord. And this one, my lord,
Jungle
is also apprehended from the spot, my lord.
Sealing and packing.
All right.
Cottage.
The petitioner is in custody since. What is the status of trial?
এটা ହେଇনি trial.
The petitioner is in custody since
12/4/2023.
12/4/2023 in connection with such case. The prosecution case is that
while sealing and stitching of bags in the cottage near
3 persons
From the spot inside the jungle area that on being
3
questioned,
persons, including the petitioner, were stitching and packing
yes, ma'am.
some gunny bags containing kete kg?
300.
My lord, 3 quintal 6
306 kgs of contraband ganja when there was a raid by police. Stop. 2 persons fled away into the jungle while the petitioner was apprehended. CSK Bhanjado, learned counsel for the petitioner submits. The trial has not commenced as yet, despite the petitioner being in custody for more than a year. He therefore submits that the petitioner may at least be released on interim bail for some period to attend to the needs of his family. Then State Council opposes the prayer for bail by submitting that there is prima facie proof of the involvement of the petitioner in the alleged occurrence. Hello. Considering the submissions as above, I am not inclined to grant regular bail to the petitioner. The bail application is however disposed of, directing the court below to release the petitioner on interim bail for a period of 3 months, each day appearance. No. No, should I recall?
No.
76. May I please, my lord? Here the accused petitioner is in custody since 14/6/2023 on an allegation on section 376 and 498A of IPC.
Notice has been issued?
Notice has been issued.
Yes?
The victim has
12/5.
12/5.
Day before yesterday.
Oh, day before yesterday. So we'll take it up on Monday, Mr. Achari.
Yes, madam.
Land State Council submits that notice on the informant/victim was served on 12/5/2024. There is no appearance from her side. Stop. In order to grant an opportunity to the informant to appear, list this case next week. Next week means there are only 2 days.
My
Next
lord,
week.
let it be
Yeah.
called on Monday. Let there
I
be
say
a-
Monday, Monday, Tuesday, ଗୋଟେ list ଆସିବ ସେଦିନ ହବ।
My lord.
Item 77.
You have the case diary?
77.
Huh.
Which one, my lord?
Yeah, previous matter, ଯୋଉଟା matter ହେଲା।
Yes, ma'am.
All right.
In 77, one of the co-accused bail application was disposed of by Honorable Justice G. Satpathy in BL appeal number 12684/2023.
No, how many?
Total two accused persons.
ବର୍ତ୍ତମାନ ବିଦ୍ୟାସାଗର ମହାପାତ୍ର ଜଣେ ତ?
Driver and one Vidyasagar Mahapatra was
And-
sitting on the rear
ନାଇଁ
seat. of the-
ଗୋଟେ ବର୍ତ୍ତମାନ ଏଇ application has been filed by only one person, ବିଦ୍ୟାସାଗର ମହାପାତ୍ର।
Yes.
এই এফআইআর দুইটা accused, তা ফার্স্ট ডিসপোজাল ବି Honorable Justice ଗୌରୀ ସତପଥୀ ସାନଙ୍କର।
ଏମିତି ହବା କଥା ନୁହେଁ?
ସେଟା ମୁଁ ଦେଇଥିଲି ସାର୍ଟିଫିକେଟ, ଆକ୍ଚୁଆଲି ମୋ ଟ୍ରାନ୍ସଫର ସାର୍ଟିଫିକେଟ ଦିଆନଥିଲା ବୋଲି ରହିଯାଇଛି ଆଉ।
ଆଚ୍ଛା।
ପଳେଇ ଆସିଛି ଟିକେ ଆଉ।
Learned,
appeal number
all right,
126.
I'll write it. Learned counsel for the petitioner submits that the first application filed, first bail application arising out of the same FIR
Same PR.
was dealt with, same PR, was dealt with by a coordinate bench presided over by Honorable Sri Justice G.S. Satpathy. G. Satpathy. What is it? Huh? Being BLAPL number
12684.
12684 of 2024.
2023. Disposed of 5 to 2024.
Disposed of on 5 to 2024. Hence registered to do the needful as per the standing order with permission of Honorable the Chief Justice.
Item 78.
Offense under section 379, 468, 471, 34 IPC. Petitioner is in custody since 7/5/2023, my lord. And
Mr. Panda, pass on the FIR if you have.
FIR. Even rough paper.
Daddy chori na kon?
No. Allegation of theft of iron pellets along with the.
Matra 30 antecedent.
I'm filing an affidavit that on all the cases he is on bail.
In all the cases you have been falsely booked. You have been falsely booked, Mr. Panda. You are an innocent
In some
person.
cases he has been remanded.
That is why you have been granted bail, because you are an innocent person.
Similar nature. All are 379, 120.
Mohammed Ansari.
And the materials have been recovered along with the vehicle.
What is it carrying iron pellets?
Yes.
Iron pellets.
The main accused person has been released on bail.
Vehicle has been seized from one co-accused Surya Oram.
All right, all right.
Thank you.
So what is the role played by this Khalko?
The allegation is that he produced the challan with a false number plate.
A
That is
fixed
the only allegation.
duplicate number plate.
No, duplicate number plate.
Yes. But the main accused with the driver, he has been granted.
Achha, the petitioner is in custody since
7/5/2023.
7/5/2023 in connection with such and such case. It is alleged that a truck carrying iron pellets from Commanda Steel Plant left for BNS Sponge Limited at Rayagad, but did not reach the destination. Subsequently, it was found that the driver of the vehicle, being associated by the present petitioner, arranged a challan for the vehicle by affixing a
Duplicate number.
Yes,
Duplicate number.
duplicate registration number with the intention of misappropriating the load, the consignment. Hello. It is submitted that the main accused has in the meantime been released on bail. Stop. Further, the truck has been recovered from the possession of the main accused.
Truck along with the materials.
Along with the materials.
Loaded truck.
The materials. The petitioner stands more or less on the same footing. Considering the above facts, as also the period of detention in custody, I am inclined to allow the plea.
Some condition, antecedent जो condition
As a condition, sir, he shall appear before the IIC of Kothana.
He belongs to Joda police station, but occurrence took place in Koida.
So he'll appear before Joda police station, IIC of Joda police station. Joda police station. Acha, IIC of Joda police station. Once in a month, and such fact shall be certified by the IIC to the concerned court. Hala. For a period of 6 months, for a period of 6 months.
Nine.
Yes.
Progressed.
Item 79.
May I please your lordship? The allegation against the present petitioner under section 20B of NDPS Act. As per the allegation on 2/11/2023, the petitioner has been
FIR नहीं किसी ने किंतु करे
40 kg.
FIR नहीं किसी ने कौन करे
FIR टा मु सेटर फाइल करना था.
It is not mandatory, but unless the FIR, the court considers the primary allegations, how will you?
The rejection order.
Rejection order আমি পড়ি বুঝি পারিব না rejection order may not reflect the correct facts. It is the FIR which will, so that I will apply my mind independently.
दिटा जरी बस्तारे 20 kg गंजे.
କେତେ ଜଣ ଲୋକ?
He is the sole accused, my lord, and one similar antecedent stands in his name.
Antecedent ଅଛି.
Sir, he was released on. Yes. 7 months, more than 7 months.
Vacation ପରେ ଆସୁ. This matter in the week commencing 8 July. Yes.
Antecedent रे bail रे जाइछि.
ଆଜ୍ଞା?
Antecedent रे bail ରେ जाइछि.
ହଉ ଆସୁ ଆଉ କିଛି ଦିନ ଯାଉ ମାସ 1.5 ମାସ ଯାଉ ଦେଖିଆ.
Honor 80.
Please, my lord. My lord, here the allegation is under section 302 read with 201 of Indian Penal Code. The incident also occurred in the year 2016. That so far the allegation of the informant is concerned that there was a dispute between the husband and wife, and that dispute was also sorted out among them. But the reason based of known how the father of the daughter also died. No one has also seen the incident, and there is no materials against the present petitioner. None of them also support the prosecution. Incident of 2016.
The last occasion, lordship called for the deposition copy from the following court bill.
It is there.
The informant was examined as PW3.
Material witnesses has already been examined.
He has killed his father-in-law.
Killed his father-in-law. And the last in theory matter that one Tukuna Barik, who is a neighbor, he has seen the petitioner and the deceased. He was not examined. And the father of the present petitioner, he has also not examined.
That is, no one has seen the occurrence. There is no eyewitness of the occurrence. Neither the daughter also stated anything against the present petitioner.
Who is the last in theory witness?
He is the Tukuna Barik male. He was not examined. Whether he was examined or not.
What has he said in his 161? ଅନ୍ୟମାନେ କେହି କିଛି କହିନାହାନ୍ତି.
61 relevant part. ଯେ ଗତକାଲି ସନ୍ଧ୍ୟା ସମୟରେ 8 ଘଣ୍ଟା ବେଳେ ନିରଞ୍ଜନ ସେଠୀ ତାର ଶଶୁର ଉପେନ୍ଦ୍ର ସେଠୀକୁ ନେଇ ଆସି ତା ବଖରାକୁ ଗଲେ. ତାପରେ ରାତ୍ର 11 ଘଟିକା ପର୍ଯ୍ୟନ୍ତ ନିରଞ୍ଜନ ସେଠୀ ତା ଶଶୁର ଉପେନ୍ଦ୍ର ସେଠୀକୁ ଗାଳିମନ୍ଦ କରୁଥିଲା ଏବଂ ଜୀବନରେ ମାରିଦେବ ବୋଲି ଧମକଉଥିଲା. ମାରିଦେବ ବୋଲି କହୁଥିଲା. ତାପରେ ମୁଁ ଅପେରା ଦେଖିବାକୁ ଗଲି. ଆସି 29/8/16 8 ଘଣ୍ଟା ସମୟରେ ଜାଣିପାରିଲି ଯେ ଉପେନ୍ଦ୍ର ସେଠୀ ଶରୀର ମୃତ ଶରୀର ଆମ ଭଡାଘର ପାଖରେ ଥିବା ପୁରୁଣା କଟକ ମେଡିକାଲ ବାଉଣ୍ଡ୍ରି ୱାଲ କୁ ଲାଗି ରହିଥିବା ଜଜାଙ୍ଗ ଗଛ ମୂଳରେ ପଡି ରହିଥିଲା ଏବଂ ଉପେନ୍ଦ୍ର ସେଠୀ ମୁଣ୍ଡରେ କପାଳରେ ଅନ୍ୟାନ୍ୟ ଜାଗାରେ ହଣା କ୍ଷତ ଚିହ୍ନ ଅଛି. That is 8 numbers of injuries is there and PM report is made due to multiple injury on the slab. And the father of the present petitioner, my lord, he has stated ଯେ ଆଜିକୁ 10 ବର୍ଷ ହେବ ମୋ ପୁଅ ନିରଞ୍ଜନ ସେଠୀକୁ ପୁରୁଣା କଟକ ଥାନା ଅନ୍ତର୍ଗତ ସାଲପଟା ଗ୍ରାମର ଉପେନ୍ଦ୍ର ସେଠୀଙ୍କ ବଡ ଝିଅ ବନିତା ସେଠୀକୁ ବିବାହ କରିଥିଲେ. ମୋର ପୁଅ ଜଣେ ମଦୁଆ ଓ ଦୁଷ୍ଟ ପ୍ରକୃତିର ଲୋକ ଅଟେ. ବିବାହର 3 ମାସ ପରେ ମୋର ପୁଅ ନିରଞ୍ଜନ ପ୍ରତ୍ୟେକ ଦିନ ମଦ ପିଇ ବହୁ ବନିତା ସେଠୀକୁ ପିଟାମରା କରୁଥିଲା. ତଥାପି ବହୁ ବନିତା ସେଠୀ ତା ବାପା ମାଙ୍କୁ ଜଣାଉ ନଥିଲା. ମୋର ପୁଅର ଉରସରୁ ବହୁ ବନିତା ସେଠୀଙ୍କର ପୁତ୍ର ସନ୍ତାନ ଜନ୍ମ କରିଛି. ମୋର ପୁଅ ନିରଞ୍ଜନ ବେଳେ ବେଳେ ବାହାର ରାଜ୍ୟକୁ ପଳାଇଯାଏ ଓ କେତେବେଳେ ଦିନ ଫେରି ଆସେ. ସେ ଯେତେବେଳେ ଘରକୁ ଫେରେ ବହୁ ବନିତା ସେଠୀକୁ ପିଟାମାରା କରେ ଓ ଜୀବନରେ ମାରିଦେ ବୋଲି କହୁଥାଏ. ତେଣୁ ବହୁ ବନିତା ସେଠୀ ତାର ଜୀବନ ଭୟରେ ତାର ବାପ ଘର ସାଲପଟାକୁ ପଳାଇଥିଲା. ମୋର ସମୁଦୁଣୀ ତାଙ୍କୁ ବୁଝାବୁଝି କଲା ପରେ ସେ ଆମ ଘରକୁ ଆସିଥିଲେ. ଆଜି ପ୍ରାୟ 2 ବର୍ଷ ହେବ ନିରଞ୍ଜନ ସେଠୀ ବନିତାକୁ ପିଟାମାରା କରି ଜୀବନରେ ମାରିଦେ ବୋଲି କହିଲା ଓ ମୋର ସ୍ତ୍ରୀକୁ ମଧ୍ୟ ପିଟାମାରା କରି ଜୀବନରେ
Mr. Panda, let it lie over. Let them be examined. Let it lie over.
Witnesses be examined. Tukuna Barik and
I'm calling it in the month of July. In the meantime, they must have been examined. We bring their depositions, we'll see. Let's this matter in the week commencing 8 July. In the meantime, the court below shall transmit the copies of depositions of
Tukuna Barik
and
Bhikari Sethi.
If examined in the meantime.
Item 81.
81, Mr. Panda, same?
Similar matter.
Are you going to same?
No. This is different incident.
Similar.
Different incident.
Similar one.
No one has seen the occurrence. There are no eyewitness. And here the allegation is also the killing your wife. 4988-302 IPC is there. 24-25-7 of Arms Act. Is in custody since 1/6/2022. Because the last occasion also a report was called for because one physically disabled sister is there. And her father is there, his father is there.
The prosecution Annapurna Kaur, Arjuna Pradhan and Krishna Kaur have been examined. If so, acha, se kaun likh le? I am submitting here with 10 numbers of depositions in all the deposition of Annapurna Kaur, Arjuna Pradhan and Krishna Kaur. They have already been examined in connection with the ST number. Form of heading of deposition. Annapurna Kaur.
Out of 36, only 6 witnesses are.
See, 3 jano witness ko katha koyଥିଲେ semana bodhe.
That they are material witnesses.
ये ना की गलो अन्नपूर्णा कौर
अर्जुन प्रधान
अच्छा बंधुक मारदेला
and Krishna Kaur.
अन्नपूर्णा कौर इज हॉस्टाइल. But both this Krishna Kaur and that Arjuna, they have said, Krishna I'm willing to discard because he reached the spot after the occurrence. But this man has seen the gun. In fact, he snatched away the gun from.
PM report is also that gunshot wound on the right side chest. And villagers detained the present petition. He has also told them. And there is
out of 36, only 6 of them have already been examined. So let the matter be taken up after vacation. If any more materials or something has come, then my lord to decide the matters.
No, that's all right, Mr. Panda.
Only my prayer.
How can you? No, that's all right.
Only my prayer, my lord, that instead of granting that regular bail, because the condition of the family is there, only 2 months in interim bail may be granted. Because the one physically handicapped sister is there and ailing mother is there. For that reason, also in the other day, a coordinated bench also inclined to grant the interim. Only the report was also called for. That is left with my lord to decide, but only 2 months. I am requesting only
No.
2 months for interim bail.
No, you were directed to obtain that health condition of the handicapped.
Yes,
the
yes,
coordinate bench.
yes, that was the directive.
Yes.
It was since long, I think.
ସେଟା coordinate bench ର direction ଥିଲା 29/11/2023. All right. So list this matter in the week commencing 8th July. Learned State Council shall comply with the order dated 29/11/2023. ମୁଁ ଏଇখানে ପାସ୍ କରିଦଉଛି as per said order the State Council was directed to obtain the health condition of the sister of the petitioner who is said to be physically challenged. Stop. Let a free copy of this order be handed over to the State Council for compliance.
Item 82.
Pass over.
Item number 83.
My lord, this is a case of offense 395, 450, 379 of IPC, my lord. Fact of the case is that the accused person, while entering into the shop of the informant, they snatched away cash, mobile phone, and other materials, my lord. And he is in custody since, my lord.
Yes.
So that the revolver and live ammunition it was seized from the co-accused.
Yes.
And against the present petitioner, there is 13 numbers of
13 numbers of articles.
And charge sheet has been submitted.
Yes, my lord.
Charge sheet
submitted.
So what about was he identified in the TI period?
TI period was not conducted.
So how was he identified?
He was remanded in this case, madam.
The petitioner is in custody since?
My lord, 16/1/2023.
16/1/2023 in being remanded in connection with such case. It is alleged that 6 unknown persons came in 2 motorcycles and one out of them threatened the informant and demanded money. Stop. He thereafter forcibly entered into the shop and took away cash of rupees 12,000 and gave a fist blow on the face of the informant. What is your name? Ajay Yadav. Another co-accused.
Sorry.
Ajay
Yadav.
Further, the culprits also showed pistol and snatched away the motorcycle of a co-villager. And also the mobile handset of another person. It is submitted that no TI period was conducted and the petitioner has been implicated on suspicion. Learned State Council submits that the कौन order recover है? The gun.
No, that was recovered from the co-accused person.
That the petitioner is a habitual offender having similar criminal antecedents. Considering the submissions, the materials on record, the fact that charge sheet has already been submitted, and taking note of the period of detention of the petitioner in custody, I am inclined to allow the prayer for bail. Let the petitioner be released. Sorry, Nimo. Let the petitioner be released. Condition Korea 1. He shall appear before the IAC of Kothana.
That is Gobindpur.
Gobindpur police station on every Sunday at 10 a.m. for a period of 6 months. So, he shall further, he is certified. He is certified by the Central Police. Further, he shall appear before the court below on each date of posting of the case without seeking any representation.
Item 84.
Your Lordship, the case may be adjourned after a vacation.
May I please?
Yes.
After vacation. I have not obtained the.
There is a prisoner's petition. Prisoner's petition, he wants to engage another counsel. Where is that petition? Petition আসছি petition তো নাই
ଆଜି କହୁଛି after vacation ପରେ କରିବା ପାଇଁ passport ପାଇଁ
Your good name?
Subhrajit Maan.
Sri Subhrajit Mahanti appears and submits, comma, he has been authorized by the petitioner through a prisoner's petition to appear. No such petition is available in the case record. The State Council is directed to take instructions in this regard from the jail superintendent. List this matter in the week commencing 8th July.
Item 85.
In this case, I have submitted the deposition copy today itself. Deposition copy of 4 witnesses.
How have you submitted?
E-filing.
E-filing. Then we'll take it up tomorrow.
Because 3 days was holiday. 10, 11, 20.
So we'll take it up tomorrow. The depositions have not been tagged to the case record. So please find out, huh? Through e-filing. He says that through e-filing. So it is being passed over, it will be called out again tomorrow. Alright. So Mogera deposition or code is so the code. It is Mogida.
Item 86.
Under the petitioner is in custody since 12th September 2023, my lord.
The petitioner had in fact issued a letter to the ISC and gave 4 checks for all these. He is ready and willing to pay some amount to the informant. Yes.
My lord, cash security, as per the order, will deposit, my lord.
What cash security? You are willing to pay some amount to the informant. Now you are saying cash security.
My lord, his old age parents, they are arranging, they have arranged some around 1 lakh. So order may be passed, will deposit in the court, my lord.
I am the court of कौन भावुचंदे आगे अरे भावुचंद जी कोर्ट रेडी बसछन सी ताके मुंड फुंड किछि
ରହିଲା ଭିତରେ ତାଙ୍କର ତ ଘରେ ବୁଢା ବୁଢୀ
କଥା ମୁଁ ଜାଣିନି ସେ ତା ଭିତରେ ନଥିଲା ଆପଣ ବିଲ୍ ପାଇଁ ଆସିଥିଲେ
ଦେଇଛନ୍ତି କିଛି ଲକ୍ଷ ଟଙ୍କା ଖଣ୍ଡେ
ହଁ
ସେ ଦେଇଦେବେ ଡିପୋଜିଟ୍
ନାଇଁ ନାଇଁ ଦେଇଦେବେ ନୁହେଁ ସେ ଦେଇନାହାନ୍ତି ବହୁତ ଆପଣଙ୍କୁ ଟାଇମ ଦେଲେ ହବନି I reject it.
My lord, cash security any order?
No, I will not grant cash security. I have said that you have yourself said that you are ready and willing to pay some amount to the informant. What cash security?
To deposit there?
No. You
1 lakh informant ଦେବି order କରିଦେଲେ ମୁଁ ଦେଇଦେବି.
ଆପଣ ଦିଅ and where is the informant? Who's
Exemption chief was had in part, my lord. Further exemption it is there. And all the witnesses have been turned hostile, man. Well, besides that, when the petitioner was in custody since 16/10/2020, man. And when he was in custody, he suffered from serious diseases. A jail authority admitted to him in category.
Where is the earlier rejection order?
That was rejected, my lord, Justice B. Narasimhan.
So let him here. Where is that order?
Downloaded copy.
I think Justice Narsingh should hear this matter.
It will be better, because he has rejected this.
It is submitted that the previous application filed by the petitioner was rejected on merits by a coordinate bench presided over by Honorable Sri Justice V. Narsingh. Learned counsel for the petitioner also produces copy of the order passed by the coordinate bench, which reveals that the bail application was rejected, considering the merits. So, in such view of the matter, it would be proper if the subsequent bail application is also considered, also heard by the coordinate bench. Registry is directed to do the needful with permission of Honorable the Chief Justice.
Item 88, not item 88 on behalf of Mr. Salman pass over.
That's all.
Item 89.
कितना अच्छा कितना अच्छा
आइटम 89 भी एफआईआर कॉपी देने काली की डाउनलोड करता
पास ओवर
काली करते बेटर
पास ओवर
एफआईआर को देता
ओके
deposition. I have got in the meantime 9 witnesses we examined. I am serving a copy of the deposition to my learned friend. So to take it up tomorrow.
Yes.
Item 90.
I'll take room.
Pass over to hello.
Yes.
Hi, please, your Lordship. Lordship, offense under section 20 of NDPS Act, 66 kgs of contraband article, and petitioner is in custody since more than 9 months. My lord, the prosecution case is that on 5th of August 2023, at about 5:30 a.m. while the excise team were performing patrolling duty near Antipatry area, they received information regarding transportation of ganja in a red color bolero. Lordship, the petitioner is a lady, and the only role played by the present petitioner is that she is a passenger, and she has no criminal antecedent, my lord. And in the meantime, 2 witnesses are examined in this case. My lord, they support the present petitioner, and that's all.
He is from Madhya Pradesh, so I will not grant bail. Yes.
My lord, she is a lady and has have 2 dependent children, my lord. They are suffering a lot.
It doesn't make any difference. Being a lady did not stop her from indulging in these activities. So why no special treatment? And that too, she is from Madhya Pradesh, commercial quantity.
My lord, I have submitted the deposition copies and they have.
No. If you so want, you may, I can permit you to withdraw. Otherwise, I am going to reject your application.
Withdraw, my lord.
Permitted to withdraw.
91. 91, may I please, your lordship? My lord, 2 petitioners before your lordships. The alleged offense, my lord, under section 302-34. There is no eyewitness to the occurrence. Yes, my lord. Only, my lord, I am reading out 2 statements. Your lordship kindly see. That is the last inquiry and the circumstances, my lord, how the. मोर नाम श्रीमती बासंती महाली आज आपनक पाखरे मोर कहिबा एही कि जे मो मोर स्वामी बाउंस पतियार झुड़ी बुणाबुणी करू पीबा पई महुली तयारी करी थाउ ओ बिक्री मध्य करू 18/10/2023 रिख दिन प्राय 1 घंटा हबो न्यू दानीर झुना पात्र दिस इज माय लॉर्ड महुली पीबा को आसीथिले तापरे राउतरापुर रो मुसा महापात्र महांतीपड़ार कालिया देउरी मध्य आसिले से माने पिउथिबा समय महांतीपड़ार नांडुपल्ली मध्य आसी महुली पीले से धरिथिबा माछकु आम चुलीरे पोड़ी खाइला और सेमानकु मध्य देला नांडु महुली पी सारी आगे पलाई गला झुना महुली पी सारी मूसा और कालिया को किछि महुली देबाकू कहिला से मना कले देबाकू झुना तार पाखरे रखिथिबा गंजेई को बाहर कला गंजेई देखि से 2 जन झुना पात्र को गंजेई मागिले सेमाने पाटुतुंड लागिबार मु सेमानकु सेठारु पलाई जिबाकू कहिली मोर स्वामी सेठारे पाछिया बुनामुनी करुथिले मूसा और कालिया आम घर पलाई गले तांको पछे पछे झुना पात्र मध्य गला से माने गाँ रास्तार नदी आड़े गले गला समय पाटितुंड हो जाउथिले दिस इज द स्टेटमेंट ऑफ द वन
Basanti my lord, and another statement is Hira Mahali. ଆପଣଙ୍କ ପାଖରେ ମୋର କହିବା ଏଇକି ଯେ ଆମ ସାହିର ସମସ୍ତେ ପ୍ରାୟ ବାଉଁଶ ପାତିଆ କାମ କରନ୍ତି। ମୁଁ ମଧ୍ୟ ପାଛିଆ ବୁଣାବୁଣି କରି ବିକ୍ରି କରେ, ବିକ୍ରି କରି ଜୀବିକା ନିର୍ବାହ କରେ। ଗୁରୁବା ମାହାଲି ପାଛିଆ ବୁଣାବୁଣି ସହିତ ମହୁଲି ମଧ୍ୟ ରାନ୍ଧି ବିକ୍ରି କରେ। ଅନ୍ୟ ଗାଁର କିଛି ଲୋକ ତା ଘରକୁ ମହୁଲି ପିଇବାକୁ ଆସନ୍ତି। ନିଉଜାନିର ଧୁନା ପାତ୍ର ମାଛ ଧରି ବିକ୍ରି କରିବାକୁ ଆସି ଏଠାରେ ମହୁଲି ପିଏ। ରାଉତରାପୁରର ମୂଷା ମହାପାତ୍ର ମଧ୍ୟ ଏଠାକୁ ମହୁଲି ପିଇବାକୁ ଆସେ। ମହାନ୍ତିପାଳରୁ ମଧ୍ୟ କିଛି ଲୋକ ଏଠାକୁ ଆସନ୍ତି। ଗତ 18-10-2023 ପ୍ରାୟ 2ଟା ହେବ ମୁଁ ଆମ ଗ୍ରାମ ଦାଣ୍ଡରେ ବସି ପାଛିଆ ବୁଣୁଥିବା ସମୟରେ ମୂଷା ମହାପାତ୍ର ମହାନ୍ତିପଡ଼ାର କାଳିଆ ଦେହୁରୀ ଆମ ଦାଣ୍ଡ ଦେଇ ତୋଟା ଆଡକୁ ଯାଉଥିଲେ। ନିଉଜାନିର ଧୁନା ପାତ୍ର ତାଙ୍କ ପଛେ ପଛେ ଯାଉଥିଲା। ସେମାନେ ପାଟୁତୁଣ୍ଡ ହୋଇ ଆମ ଦାଣ୍ଡ ବାଟ ଦେଇ ତୋଟା ଆଡକୁ ଗଲେ। ତାପରେ ସେମାନେ ଆଉ ଫେରି ନଥିଲେ। ଉପର ବେଳା ତୋଟାରେ ହାତୀ ଭୟରେ ତୋଟାକୁ କେହି ଯାଆନ୍ତି ନାହିଁ। ତହିଁ ପରଦିନ ସକାଳୁ ଗାଁ ଲୋକ ଦେଖିଲେ ଯେ ନିଉଜାନିର ଧୁନା ପାତ୍ର ଜଙ୍ଗଲ ଭିତରେ ମରି ପଡିଛି। This is the statement of all other also this
Nath Mahali.
Huh?
Last in Nath Mahali.
Nath.
It is there, my lord. No eyewitness to the occurrence, only last in theory. They have taken liquor altogether.
Any enmity?
No, that is not there, my lord. But
the motive?
That is not proved, my lord. But disclosure statement and that sickle and bamboo stick has been seized on behest of the petitioners. And the PM report, there are 8 number of
injury.
9 number of injuries.
So this becomes a very strong circumstance.
Yes, my lord.
Recovery of the weapon of offense?
Yes, that sickle and bamboo stick seized on behest of the petitioners.
And this last in theory.
Last in
these two are
theory,
enough.
they have all sinned after consuming liquor. They
consuming
gone
liquor.
together.
They all are my lord consuming. And your lordship kindly see Nath Mahali my lord friend. ଆଜି ଆପଣଙ୍କ ପାଖରେ ବୁଣାବୁଣି କରେ ମୁଁ ମୋର ସ୍ତ୍ରୀ ଅନ୍ୟମାନେ ଆମ ଗାଁ ପଛ ପାଖରେ ଆମ ଗଛ ମୂଳରେ ବସି ଝୁଡି ତିଆରି କରୁ। ଗତ 18-10-2023 ରେ ଝୁଡି ତିଆରି କରୁଥିଲୁ। ସମୟ ପ୍ରାୟ 2ଟା ହେବ। ନିଉଜାନିର ଧୁନା ପାତ୍ର ଓ ହିମାଂଶୁ ଆଲିଆସ ହିମାଂଶୁ ରାଉତରାପୁରର ମୂଷା ଓ ତାର କାଳିଆ ହୋଇ ଜଣେ ସାଙ୍ଗ ମିଶି ଆମ ଗାଁ ଆଡୁ ଆସି ତୋଟା ଆଡକୁ ଗଲେ। ସେମାନେ ଖରାପ ଭାଷାରେ କଥା ହୋଇ ଯାଉଥିଲେ। ଝୁନା ମତେ କହିଲେ ଏମାନଙ୍କୁ ନଦୀ ପାର କରି ଆସିବି। ସେମାନଙ୍କୁ ଚାଲି ଚାଲି ନଦୀ ଆଡକୁ ଗଲେ ଆଉ ଫେରି ନାହାନ୍ତି। ଗତ 19-10-23 ସକାଳୁ ମୁଁ ମୋର ଭାଇ ଲକ୍ଷ୍ମଣ ଆମ ଗାଁର ନାରଣ ମୋ ଭାଇର ନାତି ନଦୀକୁ ଝାଡା ଯାଉଥିଲୁ। ତୋଟା ପାଖରେ ନାରଣ ଅନ୍ୟମାନେ ନଦୀକୁ ଗଲେ ମୁଁ ଅନ୍ୟ ପଟେ ଗଲି।
Has the trial started?
Trial my lord I have not taken.
Let the trial begin. Let some of these witnesses be examined. I will consider. Not now.
Several
I will take
witnesses for the last scene.
Only last scene my lord. All
No, not only last scene. Last scene.
The disclosure
And
statement
27.
of sickle and bamboo.
Recovery.
Without this last scene, 27 would have had no impact. But along with this last scene, which is corroborated by several persons.
Stated that we going with bamboo stick or because that is a jungle.
You never know.
So their bamboo stick is not available, but nobody stated that we are going with any weapon, my lord. And we both the accused person first went
No,
there.
let them be examined.
Thereafter, all he
Let them be examined. Let them be examined. So we'll let it lie over.
My
This matter after vacation.
Item 92. It is lost. Under officer this is 302 and petition is custody my lord 8/9/2022 my lord. Allegation is that my lord present petitioner killed the deceased my lord due to the previous only 1300 rupees my lord. All of their statement are saying that 1300 टंका को नहीं था before the prior to years back man. This is the allegation. Now witness are there.
Yes. What is the material?
3 eyewitnesses, my lord, that complainant, the father of the deceased, mother of the deceased, and another one, Narayan Naik. Motive, my lord, that he had taken a hand loan of 1300 rupees. For that, he has assaulted. Yes. Lost an axe seized from the spot and 5 injuries, external injuries, as per the PM report. Let the 3 eyewitnesses be examined.
After examination, report.
So why don't you withdraw? With liberty to renew, or should I pass an order?
Pass.
All right.
Because it's a minor legal aid case.
Yes.
It's a legal aid case.
You are appearing through legal aid?
Yes, madam.
All right.
That's appropriate.
Heard Sri, what is your good name?
Jayanta Kumar Padhi.
Jayanta Kumar Padhi, learned counsel appearing for the petitioner, being engaged by the High Court Legal Services Committee. And Sri S.K. Mishra, learned additional standing counsel for the state. The petitioner is in custody since
8/9/2022.
8/9/2022 in connection with such and such case. It is alleged that the petitioner abused the father of the informant, to which the informant objected. Again, Mr. Bhuya, please. Objected. The petitioner left the spot, but came to the house of the deceased. Informant is who is the informant?
Informant is the father of the deceased.
man.
The deceased name is this man.
His son, that Ranjit.
Yes, my lord.
No, it is alleged that the petitioner abused the informant, and when his son protested, there was a quarrel. Subsequently, the petitioner came to the house of the informant, and when his son was sleeping, he assaulted him by dealing blows with an axe, causing his death. The occurrence is prima facie proved through the eyewitness accounts of KK,
My lord, the complainant himself, Banguru
the
Naik,
informant,
and mother of the deceased, Gurubari Naik, and one
Gurubari
neighbor,
Naik.
Narayan Naik.
and Narayan Naik. In view of such evidence, showing complicity of the petitioner, I am not inclined to allow the prayer for bail. The bail application is therefore rejected. It shall be open to the petitioner to renew his prayer after examination of the aforementioned eyewitnesses during trial.
Published.
93. So 93 on
May I please your lordship?
Mr. Sahu Malak, so were he the appearing in?
As in all, Kali.
94.
94.
Well, this is a case where last occasion, your lordships may see the charge sheet. But again, the investigating authorities do not understand what they are investigating. Well, the petitioner is a company which has created a web page 20. If your
This is
lordship
OPID matter.
no man, that is EOW matter.
The designated court like
So the EOW designated court.
EOW designated court quas. It's not an OPID
Okay.
matter.
Allegation is the sum of rupees 43 lakhs 87 was transferred by accused Karan Kumar Singh and the company from the account of iSerview Technology.
Well, here the informant has misappropriated officers of the informant company. Well, I'll just explain. The accused company, Malots, they create a software, Malots, which is a UPI, wherein Malots amounts from various banks will come to this particular software, pay in, and thereafter there is payout, which code is possessed by the client and its officers. Now, Malots, for example, 10 crores from various accounts have flown into this account. It is there lying in the wallet created by us. They can only utilize. I don't have the password. I don't have the necessary authorization. I have only the authorization to receive the amounts from various sources. Now, what happens? Some of their officers might have missed. I don't know what has happened. They say that we are finding
14 crore.
14 crores. There's a misappropriation. Now, misappropriation, how can it be done from my end, my lords, when I don't have the authorization, I don't have the account, the wallet is in their name, they only...
Just a moment, sir. Don't interrupt.
I said the account belongs.
Anyway, don't interrupt.
The account is also in their name, my lords. Everything is theirs. How can I, my lords, utilize their account? I am only a service provider.
So yes, you were directed to take instruction in this regard.
My lord. Well, before arguing this case, my lord, I want to give a sort of idea about that QR code, my lord. There is, my lord, that fraud was totally committed by means of QR code. That is totally committed by QR code, my lord. There is two types of QR code. There is one is P2P and P2M. P2P means person to person, my lord. Suppose I transfer money to my friend, that I will enter that amount and I will transfer by QR code. That is by PhonePe or by Paytm or by any means. P2M means that is to P2 merchant, my lord. To when we give money to any shop, so or any transaction was made, then that is P2M. And P2M is, my lord, it is also divided into two parts. One is, my lord, that is static QR code. Another one is dynamic QR code. Static QR code, when we give any money to a business person or in business place, my lord, then we also enter amount and we paid. In dynamic, my lord, it was basically which was seen in the petrol pump, medicine store, and other malls, my lord. When we scan that scanner, automatically display shows that this particular amount was displayed in display. It was shown. This fraud was committed, my lord, by means of dynamic QR code, my lord. That the petitioner, my lord, petitioner company, he has made as an agreement with the informant company that he provided QR code and they will say, and commission was divided into among themselves, my lord. And in my lord, dynamic QR code, my lord, what happened? Suppose we paid to in a petrol pump. That was not settled in one day. That was settled in 1 day, 2 days, or 3 days, my lord. Settlement was not immediately gone to the account of that party, my lord. It was settled after 2 or 3 days, my lord. Here, my lord, what happened in 7/6/2023 to 9/6/2023? In 12 days, my lord, there was a transaction of 15 crores 9,021. 15 crores.
No, you file a complete detailed comprehensive.
Yes, my lord.
You file so that
my lords,
and giving a copy to Mr. Kanungo so that he can respond.
I can explain.
And what
My
happened?
lords, all these things they are now they are just moving around in the air. Dynamic QR code, static. There's nothing like that. Of course, I'm not blaming my friend. My lords, the IO must be instructing him in that manner. There's nothing like that, my lords. I have been talking
what
to
I would first like to understand this.
Yes, exactly, my lords. I would also like your lordship to understand.
You file a note
on that basis.
On whatever you are submitting.
Yes, ma'am. I will
be easier.
Your lordship,
like in that Pakistan case, you had given a note that was helpful.
My lord, your lordship asked me this question. If it was prefixed, then how that money was manipulated? That is the question, my lord. Because that money was manipulated by the engineers of that.
No, because it goes to a wallet.
Goes to wallet.
Goes to wallet.
That wallet was manipulated by the petitioner's company.
Let us find out.
Because, my lord, what happened, my lord? Total amount is 50 crores.
My friend is saying runs contrary to what is stated in the chart sheet at 18.6, 18.7, 18.8, 18.9 at running page 20. So that is why, as your lordships have suggested, let him give a note.
I will give a diagram, my lord. We have also seized that 75 lakhs, which was in wallet of the petitioner's company. We have recovered, but he has not taken because he have not asked us why you have recovered that amount. Because totally, my lord, 15 crores is there. 75 lakhs we were recovered. Another is 14 crores is there. They admit that 15 lakhs we have taken from their wallet. Okay. Why you have taken? They have not taken any plea, my lord. Why you have taken that? Because
my lord, one person commission is coming to us. So, my lord, if you throw him inside jail, he cannot explain. So let them give a note.
So who has filed this?
My lord's Karan Singh.
No. Who has filed this in court? Commissioner submits a copy of the charge sheet. Same be kept on record. In course of hearing, Sri S.K. Mishra, additional standing counsel for the state, submits that he would file a chart file a note containing a graphical depiction of the alleged depiction of the modus operandi of the petitioner easy comprehension of the easy comprehension of the offense allegedly committed by the petitioner. Right. We'll take it up after vacation.
Let them give us a copy so that I can give you.
Let a copy of the such note. Let a copy of such note be served upon learned counsel for the petitioner beforehand to enable him to respond thereto. Lest this matter reopening date in the week commencing 18 June.
Well, 6/7/23 is behind bars for not committing any offense. My lords. No offense for it. Your lordships, let them give a note. 6/7/23.
No, this is a matter which cannot.
No, I understand.
This will
Your
require.
lordships will have to comprehend what actually they are trying to say, what I am trying to say.
So otherwise, I will not be doing justice to the
Exactly.
brief. I
Exactly.
may pass a wrong order, but
My lords.
it depends on my
I'm
understanding.
much obliged to your lordships for the cryptocurrency order, my lords, your lordship, because we could make your lordship understand. They also filed their note, so your lordships understood the controversy and gave a finding on it. So here also, my lords, this.
So let him be in custody. So what? The bond code.
Is mine and judge manipulated.
One of the cases, my lord, here my lord, one Rajit Jagannath has some personal dispute, civil dispute with one Gauri Mishra, my lord.
I have passed a judgment in this case.
One yellows. And here in this case, my lord.
Where is that judgment? You have that order? ଆପଣଙ୍କ against ରେ ଯାଉଛି ସେଇଥିପାଇଁ ତାକୁ ଡେରିରେ ବାହାର କରୁଛନ୍ତି ଆଉ
ନାଇଁ ଆମ against
କାଳେ ଯାଉ
ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଆଥର ଦେଇଥିଲି କପି ଦେଇଥିଲି
ଅଛି ନାହିଁ you are what is your name Rajiti
my name is in this case এটা first case ଟା 98 ରେ ଅଛି ମାନେ ପ୍ରଥମ case ଟା 82 ରେ ହେଇଛି ଏଟା second case ମାନେ first case Gauri Mishra was killed that the contact killer was killed in this case.
Oh
98 ଟା ଅଛି 98 ଟା ହଜୁର ଆଗ ନେଲେ ସୁବିଧା ହବ
98
I have to go through the CD, my lord.
ନାଇଁ
CD is available.
ମୁଁ ଦେଇ ଦେଇଥିଲି ଏ ଯୋଉ
ହେଲେ ସେ ଦେଖିନାହାନ୍ତି କଣ ମର୍ଡର କେସ୍ ତ କଣ ରହିଲେ କଣ ଅସୁବିଧା ହେଇଯିବ
ଆସୁ after
vacation ପରେ ଆସୁ ତାହେଲେ ଠିକ ଅଛି Place this matter in the week commencing 24th June. Yes. 97? 98 also, Mr. Banjade?
98 ଅଛି 98 ଟା CD ଅଛି
CD ଅଛି
98 ରେ similar
to each other.
ନାଇଁ କୋରିଲେଟେଡ ଏଟା ସେପାରେଟ କେସ୍ ସେଥିରେ 96 ରେ ପିଟିସନ ଏଇ ଯୋଉ 96 ରେ 98 ରିଲେସନ କିଛି
ହଲେ ଦେଖିଆ
98 ରେ ହଜୁର ସମସ୍ତଙ୍କୁ ଦେଇ ଦେଇଛନ୍ତି ବେଲ ସେଇଟା ମୁଁ ସିମିଲାର
କିନ୍ତୁ ଗୋଟେ ଭୁଲ ଦେଇ ଦେଇଛି ଦେଖିଆ
verify, my lord.
ନାଇଁ ସେ ଆମର
ସେଠି ଦେଖିବେନି ଆଜ୍ଞା
ଦେଇଥିଲେ
ବାରମ୍ବାର କହୁଛନ୍ତି ସେଠି ଦେଖିବାକୁ ଚାହୁଁଛନ୍ତି ଦେଖନ୍ତୁ ଟିକେ ଷ୍ଟେଟ ନ ଦେଖିକି ହେଇଯିବ
ଏଇଟା ପାସ
ମୁଁ ଆଜ୍ଞା ବୁଝିପାରୁନି କାହିଁକି ମୁଁ ରିଲିଜ କରିଦଉଛି ଆପଣ ଅନ୍ୟ ବେଞ୍ଚରେ ମୁଁ ରିଲିଜ କରିଦଉଛି ଆଜ୍ଞା ନାଇଁ ଭାଇ ଏତେ କଣ ଭାଇ ନୂଆ ପ୍ରାକ୍ଟିସ କଲା ଭଳିଆ ହଉଛନ୍ତି ଆଜ୍ଞା ବେଲ୍ ମ୍ୟାଟର ଆଜ୍ଞା ଯଦି କୋର୍ଟ ଇଜ ନଟ୍ ଇଣ୍ଟରେଷ୍ଟେଡ ସରିଲା ସେଇଠି ମ୍ୟାଟର ସରିଲା ସେଇଠି ମ୍ୟାଟର ଆଜ୍ଞା ଦ୍ୟାଟ୍ ଇଜ ଆଡଭୋକେସି If the court is not inclined to hear this matter because it is connected to another matter in which he wants to go through the record, that's all. The court wants to provide equal opportunity to both sides. That is my way. What order I will pass, I don't know. It could go in your favor, it could go in his favor. So why are you so worried? Can you be prepared? All right.
Monday next week.
All right, next week.
98 next week.
98 next week. 97, Mr. Rai?
7.
May I please, Your Lordship?
Yes.
The case under section 457 380. Custody since 22/7/23, my lords.
Charge sheet has been submitted.
Yes. Submitted allegation is from
457 380 several items, my lord. Seizure list, inverter, batteries, 13 number of solar panel, printer.
I think I have dealt with similar case.
My lord,
I have dealt with similar case.
Yes, I think.
in other cases.
28.
Where is it? Do you have a copy there, Mr. Rai?
No, those are, my lord, the other PS and other GR, my lord.
Okay.
Implicated on the
Person's namely Rajiv Pushpita. Yes.
Both your statement implicated one Sanjay Kesri. Yes, madam. But some seizure is there on 18.
No, these people have been implicated on the statement of the co-accused.
Yes, madam. This Chitra Sen.
All at all. How many petitioners are there?
One petitioner.
The petitioner is in custody since?
Custody since
22/7.
22/7.
22/7/2023. So and so. It is alleged that what is the name of this petitioner?
Chitrasen Magar.
Uh, several equipments and articles belonging to a school were stolen by unknown culprits. The unknown culprits such as smart TV, web camera, mouthpiece, and main cable of TV, etc. By breaking open the lock. Insofar as the petitioner is concerned, it is submitted that he has been implicated on the statement of one K.
Sanjay Kesri.
Sanjay Kesri, who is also a co-accused. There is no other independent evidence showing his implication, showing his complicity in the case. Then State Counsel also fairly submits that, save and accept the statement of the co-accused.
From him, several things has been seized, man.
There is no other evidence, save and accept. No, there is no other evidence against him. However, several stolen articles were recovered from the possession of the petitioner. Charge sheet has been filed.
Pilot, since long.
Charge sheet filed, my lord.
Considering the submissions as above, the materials on record, the fact that charge sheet has already been submitted, and taking note of the period of detention of the petitioner in custody, I am inclined to allow the appropriate. Let the petitioner be released.
Some stringent condition, 28 criminal incidents of similar.
He shall appear before the IAC of Kothana, Sundargarh police station on every alternate day.
My lord,
for
you
6 months.
other
And such
cases,
fact shall be certified by the IAC to the concerned court once in a month.
my lord,
He shall
in
appear. He shall personally appear before the court in session over the matter on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. Yes. Yes, Mr.
other cases, my lord, your lordship is directed to appear on Sunday, each Sunday.
But in this case, I have directed him to appear on every alternate day.
Item 99.
And this case is relating to that cryptocurrency.
Cryptocurrency.
Yeah, your lordship has already decided the issue
Yes.
relating to the cryptocurrency.
Have
these
you not challenged it, Milord? They must have gone to the Supreme Court.
Milord.
Have you not?
Yes, we have given the opinion, Milord.
Yes, yes.
We have given the opinion, Milord, today.
Correct. It's open to them.
No, what are something different?
These are.
Of
These two persons were arrested on 16/11/23.
16/11/2023. Yes.
Right.
What is the name? What is the name?
My lord, one is
Manoj Kumar Patnaik.
Hey, Basanta Kumar Orida. One is Basanta Kumar.
No, the petitioner is Manoj Kumar Patnaik.
Again,
Petitioner is
ଦି ଜଣ ଅଛନ୍ତି ଦି ଜଣ ହଉଛି ମନୋଜ କୁମାର ପଟ୍ଟନାୟକ and ବସନ୍ତ କୁମାର ପ୍ରଧାନ.
Basant Kumar Pradhan. Okay.
Both the petitioners, the allegation is against them is, my lord, they have induced persons to invest money in the cryptocurrency. And the main accused is Sudhir Chaudhary. He is from Jaipur. And he is the chairman, but everything, my lord, that person. He, in the charge sheet which was filed, my lord, except inducing persons, there is no other allegation. Nothing has been seized from us. It is single pie also not seized. Second thing is, they are the local people. And your lordship already heard. Your lordship will kindly see the allegation against the petitioners. These two petitioners.
Yes. Where is it?
My lord.
Para?
I am showing to your lordship. That is at Para. Para 1615, 1613 and 1615.
In that fraudulence by creditor, so and so, name style says when regeneration receipt introduce innocent investors to invest money. False assurance
16.13.
139.
Your RMG investigation further revealed
Again,
that fraudsters by creating
false assurance and hefty returns
no,
subsequent to S1 being operated by Sandeep Chowdhury and Basant Kumar Pradhan and others has failed to return the assured amount service and have misapproved the same. Further, they disclosed the fake apps and stopped so and so. 1615 malware.
Yes.
As the accused Sandeep Chowdhury absconded to avoid police arrest, LOC has been issued by letter number so and so against him. In this connection, Airport PS Jaipur Rajasthan was detained Sandeep Chowdhury and handed over to us. As prima facie evidence will made out against the accused Sandeep Kumar Chowdhury under section so and so. And 6 of the POCSO Act so and so, arrested him in 16/11/2023 at 11 AM and produced before the Honorable Court CJM Jaipur, Mahanagar, Rajasthan on so and brought in transit remand. Subsequently, the accused Sandeep was produced before the Honorable Designated Court under OPID Court on Ethics. Another accused person, Basanto, so and so. The allegations are against all Basant Kumar, sorry, your lordship will kindly para 16.6, my lord.
Yes.
So and so, all the platform used as promoted so and so has been given negative remark. So, that is my lord. That is my lord. Here also, the website does not show who is the CEO of the company as shown in the YouTube videos. Thus, it can be said that Sandeep Chowdhury, the self-declared CEO of Yes Bank, is a fraudster, and so also Sandeep Kumar Chowdhury, Jaipur Rajasthan, who claimed himself to be the country head of the, along with his associate, cheated the crores of rupees all over India. Investigation still reveals that around 25 lakhs were collected from 15 numbers of investors, Odisha so and so. Thereafter, my lord, the bank account of that Sandeep Chowdhury was they have seized, but nowhere it has been said that these petitioners, they are found a single file from their account. Only, my lord, they have induced persons and they are the locals, and your lordship has held in the decision that as for taking into consideration the Supreme Court decision, my lord, that section 6 is OPI Act is not made out because it is a paragraph 16, my lord. It is clear mere dealing with cryptocurrency cannot be treated as illegal in any manner. Thus, offence under section 6 of the OPI Act is also not made out. Lordship has held that. Thereafter, also have held that any document, record, etc., forged, manipulated, manufactured, etc., there is nothing, is no evidence on record. Therefore, offence under 467, 468, 471 IPC is not made out. So far as my lord, these petitioners are concerned, they are, if their FIR and investigation taken into consideration, my lord, nothing, no allegation is made out against the petitioners that they have collected the money, they have retained any money, nothing is there. Save and except, my lord, they have induced the persons. And that Sandeep Chowdhury of Jaipur, he is the head, he is talking with the, there is also allegation in the FIR, he is talking with the investors through, my lord, that video, virtual meeting, my lord. These persons, these two persons who are the locals, my lord, they are inside custody since 16/11/23.
Yes, Mr. Patra.
Here, my lord, my submission, my lord. These two persons are, my lord, are one Odisha head, another is associates, my lord. And charge sheet is clearly showing, my lord, against Basant Kumar Pradhan, induced 8,000 investors, my lord, and Manoj Patnaik induced 2,000, my lord. That is under investigation, my lord. And that apart, my lord, that the main accused, Sandeep Chowdhury, another bench, my lord, had that matter on 8/5, my lord, and judgment was reserved, my lord. My submission, my lord, that is he is country head, my lord. So let it come any other day, my lord. Because that judgment or reserved main accused, my lord. So what
The problem is I would have done that, but the thing is that I have also passed a judgment in this regard. Without my judgment, I would have definitely waited.
my lord.
My judgment is there. So once I have decided, I've taken a particular stance, even if a coordinate bench passes an order which is contrary to my judgment, I may not, So what do you say? No, you satisfy me on the merits.
My lord. Kind of a glance, my lord.
You have have you prepared a note, or I'll ask you to prepare a note, but that note should be prepared within 1 day. 1 day, both you and otherwise it will go after vacation. No, I cannot pass judgment. And
Judgment, your lordship has already
no.
decided.
I don't know. Each and every line has to be read. I may have decided the issue. So whether this falls under that category or not has to be seen.
That cryptocurrency is concerned, your
I have taken a view.
decided the issue.
I have taken a view.
Your lordship has decided that issue.
No, well, decided means by taking a view. But not me. I have also, in fact, the Supreme Court has also said that virtual currencies are not illegal. Now they say that it's a Ponzi scheme in the garb of cryptocurrency. They could be right also, but their investigation doesn't, at least I did not find any material. To my understanding, there was no such evidence. It could be true. Could be true. But your investigation should have been in that light. When somebody says, I remember that case, when somebody says that the person who was supposedly induced, he says that being attracted by his lavish lifestyle, his bungalows, his everything, I was tempted to invest money. So in a Ponzi scheme, something else happens. Chit fund, so what do you say? How do you?
My submission, my lord, this is a scheme, my lord. In the name of cryptocurrency, my lord, there are illegally money circulation.
Could be. It is possible. But there is the link. Where is the evidence?
My lord, because they are not, my lord, disclose the username and password of cryptocurrency wallet, my lord. And
in fact, they cannot.
That is one point.
They cannot, because
yes,
when somebody invests in cryptocurrency, it is his personal wallet. It remains locked up. If I remember, for 20 months, that is that includes for 20 months. Only that person who has a wallet in his name, he can operate his own account. They cannot operate.
My lord.
Unless you come for Mr. Please understand what the court wants. Unless you come forward with a definite case saying that the person who has invested in cryptocurrency and has his money is kept in a wallet, unless you come up with a definite case saying that this person, this petitioner, has withdrawn some amount from that account or that wallet, then the case is difficult to be made out. You have to show that link. If you have understood my judgment.
My lord. Then, my lord, they are saying, my lord, they are using the platform Binance, my lord. Through the cryptocurrency exchange platform, they are converting the money, my lord. And my instruction, my lord, that Binance has been banned by India government. So, my lord, they cannot use the Binance as a.
This was never your argument in the last occasion, that Binance was.
Yes, this is my.
No, now you are making that argument, but on the previous occasion you have never made that argument. Even otherwise, even accepting that it has been
banned, my lord. The exchange has been banned by government, my lord.
Banned by government. Where is that notification?
I will file that notification. Well, I have obtained instruction that has been banned, my lord. Yes, Binance. They are using that platform, my lord, converting the money. So my submission, my lord, this is not utterly cryptocurrency, my lord. Or they are all other, my lord, exchanges, my lord.
You know, I understand. I understand your point. You say that this is a Ponzi scheme in the garb of a cryptocurrency transaction. Right. So show me that link.
That
in order to bring it within the purview of the OPID Act. You have to show that they had collected deposits, giving promise of high returns. Then they misappropriated that amount, as usually happens in other cases.
160 statements are available, my lord. They are categorically stated, my lord. How they are, my lord, collected money, my lord, and saying if you will.
You file a note. Heard arguments or reserved? Parties may file their note of submissions if any by day after tomorrow.
अब क्या टाइम दे मंडे तक भाई मंडे दे दे
Monday दिन judgment. Monday or Tuesday दिन judgment. अब ता पूर्व हले हबनी. तापर मो I am going to go for vacation. My vacation will not be disturbed.
डे आफ्टर टुमारो
I have severally day after tomorrow. कौन अपन लिखित already you have that material. You are not going to create any new material.
by Friday
So that Binance thing, all right, by Friday. That Binance thing, if you are saying that it has been banned, you must get a copy from the through the WhatsApp.
my
RBI रे जदि गोटे थिबो
by Friday
all right.
okay
Yes. Item 100. Item 100.
On behalf of Mr. S.K. Dwivedi, kindly.
All right, please this matter after vacation. All right, shut up.
Item 8, I pray after vacation.
Good.
চার্জশিট কপিটা দিলি
Item
8, pass over.
Item 8 after vacation.
Item 8.
हाँ पास हो गया item ये था item
ନାଇଁ ଦେ ତାଙ୍କ ନାଁଟା ଚଢିଲେ ତାଙ୍କ ବିଲ୍ ଯିବ
नहीं सेटा मुझे जाननी 24 matters are there pass over matter will take it up tomorrow
8 खाली okay.
8 था तो बोला 25 चला तो
Item number 34 yesterday pass over.
yes tomorrow it will be taken up tomorrow